ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್? ಹಲೋ ಹಲೋ.
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ ಸರ್, ಓಕೆ ಸರ್.
ಸರ್ ವಿಡಿಯೋ ಆಫ್ ಇದೆ.
ಕೇಳಿಸ್ತಾ ಇದೆ? ಓಕೆ ಸರ್, ಓಕೆ.
May I make a mention?
Please wait, please wait. Yes. You remember? Ah. Sorry, 2008, madam. Sorry. Sorry. Please. What is this? Sorry.
May I make a mention?
Please wait, please wait. Yes. You are free to take adjournment. Okay. Sir, this is listed for admission 2013. Next,
Serial number
Submission,
27,
my
my
lord.
lord.
number 20.
7, settlement talks are going on. I have informed the other side.
There was actually a settlement talk which is going on, but his client is in the hospital, so they sought
The
the
request of the council for the applicant and the respondent just next week.
Serial number 2,
10
my
days
lord.
time may begin.
Number 2, it's in the orders list, madam. Please wait.
Yes.
Yes. Mr. Ganesh, next week.
Yes, my lord. Yes, my lord. Thank you.
Is anybody else? There is. Well, it is filed. Check mark. Council for the appellant submits that an application to bring the legal representatives of deceased respondent number 7 is filed on 12th of January. 12th January. Get verified.
List 1 of serial number 2.
The copy of the statement of objections. Copy of the statement of objections filed by the learned counsel for the respondent. By the appellant is served to the learned counsel for the respondent. Yes. List the appeal for final hearing. List the applications for bringing the legal representatives of the deceased respondent number 7 on record. Yes.
Respondent number 4, my lord. Appellant counsel is muted.
I appear for appellant, my lordship. This matter has been settled. So for reporting settlement, I pray for 3 weeks time, my lordship.
That a fact.
Settlement talk is going on. I
My lord,
appear for appellant, my lordship.
I will seek instructions, my lord, because I was implicated subsequently. I'll just seek instructions.
I kindly adjourn it for 3 weeks, my lordship, to report settlement.
Sorry, madam, no 3 weeks. These are all old matters. Counsel for the appellant submits that settlement talks are on. Seeks time to report a settlement. List on 18th March as a last chance.
So for respondent number 2, my lord, I'll take steps, my lord. It's so for IA number 2 of 21 continuation of it does not survive of COVID-19 relaxation beyond the Supreme Court, my lord.
What about R2?
R2C, my lord.
Notice has gone on not IA number
Appellant.
2. No. Has notice been issued on this IA 234?
The appellant, my lord. Appellant.
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 Cool. An application is filed IA 2 of 2021 for condonation of delay. In view of the COVID-19 pandemic, during which the time was enlarged for filing applications for IA2 of 21. Enlarged, there is no delay in filing the application. So hence IA2 of 21 is disposed. IA3 of 21 is in view of the order passed on IA2 of 2021, IA3. So far as IA4 of 2021 is concerned, this is an application filed by the applicants to come on record as the legal representative of deceased appellant 2C. Since the cause of action has survived the death of appellant 2C, the application is allowed and the applicants are permitted to come on record. Next one. IA1 of 21 is filed to bring the legal filed by the applicants to come on record as the legal representatives of deceased appellant number 8. Stop. Since the application is filed in time and as the cause of action has survived the death of appellant number 8, IA1 of 2021 is allowed. The applicants are permitted to come on record. Filed stating that the appellant number 5D died issueless. Who are the legal representatives?
There's no limit now, there is just.
Died issueless. But they are going to over. We have to party. There's no legal representative. What is the problem? What is the procedure? Yes, Mr. What is the procedure? Official receiver. What is the procedure, Mr.? For you.
To be appointed. May I intervene?
Yes, please.
Order 22 rule 4 capital A.
North side.
Administrator is to be appointed.
Government counsel for the appellant seeks time to ascertain whether he has left behind any legal acts. To stop. Counsel for the appellant is directed to amend the cost taken during the course of the day. This is the appeal for. It is also stated that the respondent number 2 has expired. 2 weeks time is granted to take steps in respect of deceased respondent number 2. Failing which the appeal against respondent number 2 shall stand abated. Next. IA3, 4.
Manoj, I represent the respondents 2 to 6 in this matter.
IA3 of 2021 is filed for condonation of delay in filing the application to recall the order dated 4/12/2020 and 23/9/2021. The cause shown for the delay is accepted as sufficient reason for not. Pardon?
I have a submission to make in this matter.
Yeah, let this application be allowed. It's only for recalling the order.
Please, Manoj. So this second appeal is disposed of on merits by order dated 4/12/2020. Subsequent, one more application is filed in IA1 of 21, seeking recalling of the judgment. It is not for review. That is also dismissed. Now the present application is to seek recalling of the order on IA number 1 of 21 and my lord's judgment also. So an application in this matter cannot be filed. Condone ಮಾಡಿದ್ರೆ again they take advantage. Still now he has not filed any SLP before the Supreme Court.
Cool. IA number 4 of please wait. IA4 of 2021 is filed to recall the order dated
4/12/2020. The judgment.
Order dated 4/12/2020.
That's a judgment on merit.
Yeah, please wait. Please wait.
Please, my lord.
The scene that the order dated 4/12/2020 was passed by this court after hearing parties. The appellant contends that certain facts were not considered by this court. And therefore, the order dated 4/12/2020 deserves to be revisited and reviewed. So, the appellant is agreed by the order dated 4/12/2020. He is bound to challenge it in the manner known to law. He cannot file an application to recall the said order. So hence IA 4/2021 is rejected. Yes.
The other two applications also consequently disposed of.
What are the other two applications?
One, IA 1/21 was filed to recall the very same judgment, which was dismissed on merits on 23/9/2021.
No, if it is dismissed already,
He files one more application to recall that order again.
it's all right. That is 23/9/21.
Please, my lord.
Yes, quickly.
In view of disposal of IA 4, the other two applications.
IA number 4/2021, IA number 1/2021 does not survive for consideration.
Please, my lord. Obliged.
My lord,
Appealing for the appellant, my lord.
no, my lord. IA number, I am the appellant in the case. And I am the appellant in the case,
Yes.
appellant 2. And I have filed the IA with for requesting for a condonation of delay.
The delay is condoned, but the application to recall the order dated 4/12/2020 is rejected.
Because, see, there is, I have filed the IA.
So there is a proper procedure. There is a proper procedure. Please follow that procedure.
My lord, one small submission, my lord.
Yes.
One small submission. I have
Yes, please.
cited a Supreme Court decision in the IA.
Yes.
And the Supreme Court decision says, I'll read out the.
Yes, please.
No, the Supreme Court order, judgment, AIR 2000, Supreme Court 1165, United Insurance Company, Rajendra Singh and others have stated that orders obtained by fraud on court can be recalled under section 151, 52, 53 of the Civil Procedure Code. Now, what has happened is, in this case, serious fraud has taken place.
Before the High Court.
What?
Has he played fraud before the High Court in obtaining an order?
Yes. That is the very reason why I have filed this application. High Court fraud in a very serious matter, Your Honor.
What is the fraud played?
See, when the will has been produced.
Don't argue on merits, mister. You have already argued the matter on merits. You have obtained an order on 4/12/2020. If he has played fraud, no, please listen to me. If he has played fraud before the High Court in obtaining this order, then you are entitled to seek for recalling.
Yes.
What is the fraud played before the High Court?
Now, the suit scheduled property has not been sold, but the judgment says it is already sold. In paragraph number 13, and I have mentioned in the IA. I'll read out the IA, Your Honor.
Yes,
please, for the reasons stated in the accompanying affidavit, the Honorable Court will be pleased to recall the judgment and judgment and decree dated and the order on IA-1 due to serious fraud, mistakes, errors, omissions, commissions, misstatement in it. The judgment passed in RSA 935/97 on 2/12/98 is disobeyed. There is already a judgment order, Your Honor, and that has been disobeyed in the judgment passed in 341.
There is something called review of the order, Mr. File an application to review the order. You can't file an application to recall the order dated 4/12/2020. If you have any grievance about the order passed by this court, file an application in accordance with law under Order 47 Rule 1.
But there is Supreme Court judgment says you can file it.
So therefore,
and-
Mr. You are a party in person, you do not know the nitty-gritties of law. Either you consult somebody, or you engage somebody, or you read the law properly. If there is a judgment against you on 4/12/2020,
and substantial question of law, which was framed by this honorable court, have not been considered in the judgment passed.
therefore that is a ground for appeal. You please challenge it before the competent court. If this court has not properly considered your case, please challenge it in the manner known to law.
I may be permitted to read the IA, Your Honor. Please, please.
Read from
Judgment.
paragraph number 1.
Yes. The judgment passed in RSA 935 or 97 on 2/12/298 is disobeyed in the judgment passed in RSA 341 of 2006. This court cannot say that the order passed by this court is non-earnest and ignore it. The judicial discipline is not, the judgment is not followed. Now, the decree drawn by this court is erroneous. There is omission of sale consideration paid on the scheduled property. There is omission of land conversion. All these figures have been admitted.
Please read, Mr. Don't argue. Please read.
There is omission of land conversion fee paid as per the condition to the government, and the land development with other costs incurred in the after admission of appeal RSA 341 to 2006 on 22/6/2009. This honorable court has framed 3 substantial questions of law that arose for consideration in the present appeal are not answered in the judgment. When the court, whether the issue, what is the substantial question law framed by this honorable court, whether the court were justified in dismissing the suit and coming to the conclusion, in spite of coming to the conclusion that the agreement of sale dated has been proved by the plaintiff before the trial court, and whether the court will have considered that available information properly in correct perspective, whether the lower appellate court has committed perversity in coming to the conclusion that the defendant had proved repudiation of the agreement, and in that regard, whether evidence considered while noticing Exhibit D15 would admit perversity, whether the reconciliation as made by the lower court is contrary and beyond the scope of remand made by this court in RSA 935 or 997. Now, RSA 935 is in my favor. The above question of law have not been answered in the judgment dated 4/12/20, and it is falsely stated in the judgment. It is answered. Further, in the order on IA1, regular second appeal, regular second appeal is wrongly mentioned as second. In the IA1, I have mentioned is regular second appeal. In the order, he says it is second regular appeal. Further, in page number 13 of the judgment, it is falsely stated that the plain scheduled property was already sold to defendant 2 to 10. Again, in page number 19, it is falsely stated the execution of registered sale deed by the defendant. No sale deed has taken place. In page 36, it is falsely stated there are no exhibits marked, although 32 exhibits have been marked by the appellants. With fraudulent intention, the respondent prepared a fake will and produced in the court with the signature of the respondent 1 forged in it, and claimed the property illegally. Appellants 2 filed IA number 2 to delete the respondent 2 to 6 from the appeal. Moreover, the will was prepared and produced when the injunction order and the stay order of the Honorable High Court of Karnataka is in force. The order passed still now. This Honorable passed an order on 27/7/2018 that the order on IA2 shall be passed at the time of final hearing. So far, no order is passed on the judgment. It is falsely stated in the judgment in page number 30 or 40 of the judgment, the plaintiffs are not ready and willing to perform the contract, despite the substantial question of law framed by this court on 22/8.
Please file an application order 47 Rule 1 if you are interested. However, liberty is reserved to the appellant to seek review.
I have a question on this.
Yes.
With regard to liberty, my lords, I have a submission.
Let him file an application. I have not said that we will allow the review petition.
No, even if the liberty is given.
For the, however it is open, wait, sir. However, it is open for the appellant to file necessary application and order 47 to 11, 47 to 1 of the Code of Civil Procedure. The same shall be considered in accordance with law. Let him file. Let us.
No, I just want one submission to make. I'll just take one more minute.
Yes,
In
please.
this matter, if your lordship would kindly see, my lords, the affidavit what is filed. There are allegations cast against the judiciary by this party who has been
It's
conducting
all
the
right.
case.
He's a party in person, Mr. Kaundinya. He's a party in person.
From 1982,
All
he's been
right.
doing the same thing. And second thing, my lords, in the affidavit, there are two appellants in this matter. Appellant number 1A and appellant number 2. In the cause title earlier, he was shown as the power of attorney holder.
Yes.
Earlier. Now, my lords, in this present affidavit, what he has filed, he only says, I am swearing to this affidavit on behalf of the first appellant, who is my brother. He is not stating to be the power of attorney holder. Now, the question, my lords, like this litigation being continued from my lords from 1982, for no reason or other, he wants to keep the litigation pending. If this liberty is given to file a review, he is going to take further advantage.
Even if I don't give a liberty, he is always entitled to file an application for review.
If this observation is made, it will always cause a trouble.
No problem. Nothing will happen. Yes, next.
It's time to verify the cost. Because coding is not at all.
What, madam? Have you filed the paper books? Office to check. Office.
3rd March 2020.
Office is directed to verify the paper books and list the appeal for final hearing as per seniority.
Sent to the party monarchs to serve the council who is appearing in the execution proceeding. But office is insisting to furnish the name of the advocate. Parties are taken the papers on service of the advocate who is appearing in the execution proceeding.
Yeah, yeah, 1 of 14 ಇದೆಲ್ಲ ಏನಿದೆ?
1 of 14 is for condemnation delay. What has happened before the trial court, after the decree passed, the trial court Spanish petition was filed. But that was also dismissed. Subsequently, the present appeal was filed. They were prosecuting the miscellaneous.
What is the suit for?
Suit for declaration.
What has happened to the suit?
The suit was dismissed. And lower appellate court reverses the finding. And based on that, my lords, the miscellaneous petition was filed. Because that miscellaneous petition was later on dismissed, my lords, as not maintainable.
The miscellaneous petition was filed where?
Before the lower appellate court.
Right, because
so what has happened, my lord, there was wrong guidance, my lords, to the parties. But since they stated that the advocate for the respondent for the lower appellate court and not argued, my lords, judgment on decree was passed. This is the ground in the miscellaneous. Based on my lords, ultimately, my lords, it was dismissed as not maintainable. My lords, subsequently, it has been filed. Yes, notice has been issued, my lord. I have served execution petition has been filed. Because I filed, my lord, I filed acknowledged, my lord,
also it was apparent 6 times. After 1 week.
What's up?
ಯಾರು ತೀರೋಗಿದ್ದಾರೆ? Who has expired?
Sole appellant died.
Yes. When did he die?
He died on 18/4/21.
The stated that the appellant, sole appellant died on 18/4/21. The learned counsel for the appellant submits that she has no instructions and that necessary steps should be taken to bring the legal representatives of the appellant on record. 10 days time is granted to do the needful, during which the appeal shall stand awaited. 10 days time. Yes. ಯಾವ್ದ್ರಲ್ಲಿ? Yes. ಮನೆಯಿಂದ ಇದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅದು ಮಾಡಿ. ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿದೆ? Yes, Mr. Ravi Shankar. Kashimat. Kashimat.
My lords, I seek passover in this matter, my lords.
Madam, the rents are not paid as
My lords, I seek passover, my lords. I'll make submission. Please, my lords.
Passover. If rent is not deposited, we'll vacate the interim order, madam.
Please, my lords, I will pass over.
Serial number 9, I appear for the appellant in this matter, Lord, for the appellant. With respect to the certain office notes, it has been raised here, Lord, for today. With respect to that death of reporting the death of respondents number 11 and 12, we have no objections here, Lord. With respect to the death of
what do you mean, no objection, Mr.
You have to take steps, my
We
lord.
have to take steps.
We'll take necessary steps.
There are no
We'll
objection
take
for
necessary
that man to die. Yeah.
No, sir, certainly, Lord. We'll take necessary steps in that regard, your Lord. And with respect to then we will take necessary
2
steps.
weeks time is granted to take steps in respect of deceased respondents as well as appellant number 6 and 10. In the meanwhile, the requisite process fee to issue notice to the unserved respondent shall also be paid. Paid in which the appeal as against respondent number 1, 6, 11, 24, 25 shall stand dismissed without reference to the bench. Shall stand dismissed. Then I have proposed respondent.
We have filed the application, my lord, because our property also involved in it, and behind our back they have taken the judgment. It will be considered along with the main matter, my lord.
But why should you come here in this appeal? In the second appeal, you file a suit and protect your possession.
No, connected another RIC is pending before this honorable court, my lord.
Filed by you.
No, filed by another.
Whatever it is, if you are not a party to this suit, and somebody else has taken decree against your property,
yes, ma'am.
Protect your possession and the right by filing a suit.
No, to bring the that fact to the notice of this house. So my presence.
All right, what can this court do? See, this decree will only bind the parties to the suit, not the parties, those persons who are not parties to the suit.
No, to show that how that fraud paid by the trial court. Trial court dismissed the suit. Appellate court, insofar as
we cannot entertain you. We cannot entertain you. If you are interested in your property, you file a suit and protect your possession.
That application will be considered at the time of final hearing, but I am not disturbing this honorable court. It will be heard along with the main matter.
IA 1 of 2021 shall be heard along with the main appeal.
Yes.
ಯಾವ್ದಲ್ಲಿ main state is a party. ಯಾವ್ದು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ನಿಮ್ಗೆ? What is not served? What is not served to you? ಏನ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ? Sir, please serve a copy of the appeal memorandum to the government advocate.
I'll take necessary.
For the appellant is dead.
Service of the copies, your Lord.
And other copies of the appeal memorandum along with the copies of the judgment of the trial court and the first appellate.
My apologies, your Lord, for
Issue number 10.
Not preparing for the appellant, seeks a 3 weeks time, for paper.
IA 1 of 2022 is filed for early hearing of the appeal Since the appeal is admitted on 9/8/2021, IA 1 of 2022 is rejected. This the appeal for final hearing as per seniority and after paper books are filed. 2 weeks time is granted to do the need.
OS number 320 ಅದೇ ಡಿಗ್ರಿಯಲ್ಲಿ ಮಾತ್ರ 330 ಪೇಜ್ ನಂಬರ್ 43 ಪೇಜ್ ನಂಬರ್ 43 OS number 330 ಡೇಟೆಡ್ ಕರೆಕ್ಟ್ 324 OS page number 43.
Office objection regarding discrepancy in the suit number mentioned in the trial court and the first appellate court. The overall, what is his date of disposal of OS?
Disposal of 24/11/2019. Already other partition is admitted.
What about the signature of A2 and A4?
Signature, my lord. First, second appellate, Sudhamma, Sudhamani and Sudhamma.
What is correct?
Sudhamma, Sudhamani is correct.
The counsel for the appellant submits that the name of appellant number 2, appellant number 4.
Appellant for Shanta Kumari and Shanti and
The counsel for the appellant submits that the name of the appellant number 2 and appellant number 4 is properly stated in the cause title and that they have signed differently. Full stop. The explanation offered is accepted. List the appeal for admission. Early, let it come for admission. Yes. What is IA 1 of 2021? Before vacating interim order to the.
That is filed by the respondent. And I have not been served a copy of that.
Yes.
Respondent to order.
Yes.
1302 part 20. Respondent on to this.
Madam, please attend to these office objections. There are some office objections on IA 1 of 21. You have to correctly state the date of the ex parte interim order. 1 week time is granted to comply the office objections on IA 1 of 21. There are R4 yaru Satyanarayana. The notice issued to respondent number 4 is received by a person named Satyananda, who is not a party to this appeal. Hence, the service of notice in respect of respondent number 4 is not sufficient. Issue fresh notice to respondent number 4. Counsel for the appellant shall pay requisite process fee during the course of the day. IA 2 of 2020 shall be considered along with the main appeal. Paper books to be filed within 4 weeks, 6 weeks. Yes. He heard sir, I'll ask him to furnish. Why don't you ask him? Please ask him. If he doesn't furnish you, then we'll bear it.
The respondent one was on the previous interest.
Please serve a copy, Mr.
Interim
Model granted release extended to the next period. Time is granted to do the need.
Please, I have to take step, not fresh steps. Get it done, not within a matter of 1 week. No.
I appear for the appellant that I filed an application for early hearing. The paper books are already.
1 of 2022 is allowed. This is the appeal for final hearing as per seniority. If paper books are filed.
Paper book is already filed.
My lords,
Yes.
I appear for respondent numbers 1 and 2, my lords. On submission, my lords, here, the appellate in appeal number 2819 of 2010 is no more, my lords, and he is survived by 3 sons and 4 daughters.
Who has expired?
Appellant in appeal number 2819, namely Hanumantarayappa.
First appellant.
You are the counsel for which respondent?
I appear for respondent numbers 1 and 2 in all the appeals, my lords.
Mr. N. Lokesh.
Yes, I appeal for the appellants.
N. Lokesh or?
None, sir.
Good. N. Lokesh, learned counsel for the respondent 1 and 2. In RSA 2819 of 2010 submits that the appellant has expired. Yes, who are the legal representatives?
And he is survived by 3 sons and 4 daughters, my lords.
And that he is survived by 3 sons and 4 daughters.
Already sons are on the record, my lords. So far as daughters are concerned, they are not the parties to the appeal, my lords.
He submits that the daughters, while the sons are on record, the daughters are yet to be brought on record. Counsel for the appellant seeks time to take steps to bring the legal representatives of the deceased appellant on record.
Appellant number 1.
My appeal also that I have to take.
Appellant number 1. Yes, in your appeal?
In our appeal, my lord, that he is the respondent.
Respondent number 7, my lord.
7, my lord.
RSA 85 of 2011 ali stated that the respondent number 7 has expired.
And in appeal number, my lords, in appeal number 2900, he is also respondent number 7, my lords. This is ranked as a respondent number 7.
Yes. Whether in a first in RFA 85, whether the respondent number 7's children are there on record?
The two children, the sons are already on record. The first, the appellant is one son, and the 6th respondent is also the
representative of appellant number.
Right, the 85 of 2011.
Respondent number 2 has expired and that is
Respondent number 7 has expired and that the 2 sons are already on record. So he submits that there are other legal representatives who are to be brought on record. This is time to take steps to bring all the legal representatives of respondent number 7 on record.
2,900 is described as 7th. Oh, bless.
Respondent number 7, 14.2. Yes, Mr. Venkat Reddy.
Respondent number 1, line 1.
Respondent is already on record. Also for R1B. R1.
I represent for R2 million.
For R1 for R3 million. R1 carry. Madam, R1 comes.
My lord, R1 is dead and LR's application are filed by the appellant, my lord. 1A is already on record, my lord. They have to take steps for 1B, my lord.
Yeah.
His son is for the examination.
Mr. Rajendra, ಸ್ವಲ್ಪ mute ಮಾಡ್ಕೊಳ್ಳಿ. LexNexus, please mute your mic. Yes. Yes, madam, one year actually. Yes, who has entered appearance for 1 year?
My lord, I appeared for Rajachar, my lord. He is already on record as a second respondent, my lord.
He is none other than the sister of Rajachar, my lord.
You accept notice for 1B? That's your sister?
She is a sister, my lord, but my client submission that there is strained relationship between him and her sister, my lord.
Notice to respondent number 1. During the course of the day, I will take out.
2011, madam.
During the course of the day, I will take out notice.
The learned counsel for the appellant submits that she will take steps. She'll pay the requisite process to take out, to issue notice to respondent number 1B during the course of the day. If the process is paid, office is directed to check, verify and proceed to issue notice to respondent number 1B. About this IA 1, 2, 3 of 15, same, huh? Yes, next. IA 1 of 2022 is allowed. This is the appeal for finding as per seniority. Same order. Date is seniority prakara barutte.
Problem is that
Sir, we can't give a date because we do not know the seniority.
only request to last they have filed an execution petition in last. What they are saying is relying upon the judgment of the honorable apex court. The interim order granted by this honorable court has been restricted to only 6 months. Therefore, you have to get a fresh order. That's what the executive court is saying. Therefore, my lord may say that interim order earlier granted extended. INL ಅದನ್ನೇ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ.
Interim order itta?
ಇದೆ interim order was granted as early as on 9th October 2012.
9th October
2012.
After it was admitted, it was not granted.
It was admitted on 28/8/2019.
Of course, since the number 16 and since the appeal was admitted on 28/8/2019, the interim order granted on 9/10/2012.
Execution proceedings ಹಾಕಿದ್ದಾರೆ ಇವಾಗ 2021 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅವರು based on that decision.
Is extended until disposal of this appeal.
I appear for respondent number 1 and 2, my lord. I filed an application for early hearing in this matter.
Yes.
My lord, I request my lord to fix a date.
IA 1 of 2022 is filed for early hearing. The same is allowed. List the appeal as per full seniority.
Can you fix a date?
No fixing a date, Mr. There are 2007, 2008, 2009, 10, 11, 12.
Also, kindly consider respondent number 1 is 85-year-old.
It doesn't matter. Yes.
20, my lord, that I appear for.
See number 18, please wait.
I have responding. I have filed this application my lord seeking direction to the appellants. Deposit the rental amount which they have been receiving in respect of my share is concerned. You will also.
Who appears for the respondent? Appellants. Rao Associates by Chowda Reddy.
I served them copy my long back. 17/11/2011, 21. I filed the application. All the matter my lord.
There is no representation for the appellant. The objections fail agidya.
The objection is ಏನು ಆಗ್ತಾ ಇಲ್ಲ ಅವರು ನವೆಂಬರ್ ತಿಂಗಳಿಂದ ಇಲ್ಲಿವರೆಗೂ ಏನು ಆಗಿಲ್ಲ. ಡಿಪಾಸಿಟ್ ಆಫ್ ರೆಂಟ್ ಗೆ ನಮ್ಮ ಶೇರ್ ಅಮೌಂಟ್
counsel for the respondent number 1 submits that he has filed IA 1 of 21 for a direction to the appellant to deposit the rent. This application is not opposed by the counsel for the appellant. This since the appellant is not represented, 1 week time is granted as a last chance for the appellant to object to file objections if any to IA 1 of 2021, during which the appeal will be, application will be taken up for consideration. Yes. This the appeal next.
My lord, I appear for appellant, my lord. 36 days delay in filing the appeal, my lord.
There is no case in the High Court which doesn't have a date. So is it next week and the next week will work. Yes.
My lord, 36 days delay in filing the appeal, my lord. Notice has been given. Notice hogilla.
Issue notice on IA 1 of 2016. ಏನ್ರಿ ಇವಾಗ 5 ವರ್ಷ 6 ವರ್ಷ ಆದ್ಮೇಲೆ ತರ್ತಾ ಇದ್ರಿ appeal ನ?
Post ಆಗ್ಲಿಲ್ಲ.
6 years.
ಮೆಮಾ ಹಾಕಿದ್ರು ಪೋಸ್ಟ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ ಅವಾಗೆಲ್ಲ.
Yes.
I appeal for the appellant in the cross objection. This is covered by the Vinita Sharma's case that they have.
Who appears for the respondents? Mr. Sabarat, Mr. Sabarat Balgangadhar. Yes. What has happened?
That the earlier milord that the suit was decreed in totality, and the first appellate court milord they have taken up such contention that in respect of 2 items, that 3 items that it was rejected. Then I carried an appeal, and that is also challenged here. In the first appellate court, that the social item of loan is also declared that the joint family property, I am entitled for a share. In the appeal, my lord, now it is admitted, following the judgment of Prakash Kulapati, that I am entitled for share as provided in section 6. That in view of the Vinita Sharma, my lord, again I am entitled. The cross objection I have filed for.
Who appears for the respondent? Who appears for the respondent?
Sabarad is appearing that he told that he is having some matters in trial court. If the date is fixed, not that will he is also cooperating and he will address.
This the appeal for. There is no representation for the respondent. Since the appeal lies on a narrow compass. Since the questions of law raised is covered by the judgment of the apex court in the case of Vinita Sharma, I'll list these appeals on 16th.
Obliged.
Asked him, not ready to pay, will not go for in the similar time. One appellant is there, my lord.
I appear for the
settlement.
My client, my client's instruction is that all the houses have been vacated.
No, but there is one house, Pakka house.
6th appellant is
constructed by the appellant number 6. So therefore I suggested your client to leave away this house by taking some consideration.
Unfortunately, I have the phone number of one client, one of the clients. She is not responding properly. One. Secondly, he says they have all vacated the houses.
Correct, not all of them, except one. All of them have vacated. This is what the appellants also say.
some reasonable time maybe because we don't want to enlarge this that at this stage.
Yes, to how much time are you willing to give him to vacate? Where you have any photographs of the building?
Old house.
6 months time.
6 months time.
6 months time to vacate.
Yes, yes, please.
His appeal is dismissed. So time of 6 months is granted to the appellant to put and deliver vacant possession of the premises. Appellant number 6 Antima. Appellant number 6 Matatana. Password. We can't assure you, Mr. Mr. KG Shantappa.
23 KG Shantappa.
Asur.
24 Ankarappa.
Mr. Mahantesh Osmat. Third reason.
Declaration question, my lord. Concurrent finding, my lord.
Yes.
Plaintiff, appellant and respondent are others, my lord.
When you are arguing this regular second appeal, please stick to the past title of the trial court. Yes, the appellant antira, defendant antira, plaintiff antira. We do not know where you are going. So therefore, please stick to the past title of the trial court.
Plaintiff and defendant are the brothers, my lord. One Naganna and Nanjappa are the son of the Naganna.
Naganna and Nanjappa are the sons of?
Son of Puttappa. Two brothers. The Nanjana and Naganna 24/4/1919 this partition, one partition.
24/4/1919.
This equal partition, madam. 23 survey number. It is put at that, madam. This 23/1 and 23/2 equal partition. The defendants and plaintiff are enjoying the fruits of the property 1919.
Yes.
There is no dispute. The plaintiff immediately filed 2003 declaration question. After 84 years, madam. Today, question is 12 years, madam. Only encroach the 12 guntas of the property. Defendant is the encroached in the 12 guntas of the property, survey number 23/2. As per survey report, the survey report is clearly mentioned, my lord. Survey CW1 is stated in clearly.
But this driving. Prakash ಅವರ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕು. ನಿಮಗೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್?
23/1. 23/1.
You did not get anything in 23/2.
23/2 is the plaintiff property.
ನಿಮಗೇನು ಇಲ್ವಲ್ಲ ಅದು?
ಇಲ್ಲ ಇಲ್ಲ.
Why are you bothered?
ಆ 23/2 ನಲ್ಲಿ 12 ಗುಂಟಾಸ್ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ವಿ ಅಂತ.
ಹೌದು, ನಿಮ್ದು ಇಲ್ವಲ್ಲ 23/2 ನಲ್ಲಿ.
ಈಕ್ವಲ್ ಅಲ್ಲ, ಈಕ್ವಲ್ ಬರುವ.
23/1 ನಿಮ್ಮದು, 23/2 ಅವ್ರದ್ದು. ಅವ್ರು ಹೇಳ್ತಿದಾರೆ ನೀವು 12 ಗುಂಟೆ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೀರ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನೀವು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀವಿ. ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಮಾಡಿದ್ರೆ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಸ್ ಪರ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್.
ಮಾಡಿಲ್ದೇ ಇದ್ರೆ ಇಲ್ಲ, ಮಾಡಿದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಹ್ಯಾಂಡ್ ಓವರ್ ಪೊಸಿಷನ್. ವಾಟ್ ಇಸ್ ವೈ ಶುಡ್ ಯು ಚಾಲೆಂಜ್ ದಿಸ್? ಆಯ್ತು ರೀ, ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ರೆ ದೇರ್ ಇಸ್ ನೋ ಎಕ್ಸಿಕ್ಯೂಟಬಲ್ ಆರ್ಡರ್ ಅಟ್ ಆಲ್. ಎನ್ಕ್ರೋಚ್ ಮಾಡಿಲ್ದೇ ಇದ್ರೆ ನಿಮ್ಗೆ ತೊಂದ್ರೆ.
ಈಕ್ವಲ್ ಸೇರ್
23/2 ನಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದ್ರೆ ವಾಪಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 23/1 ಅಂತ ಹೇಳಿದಾರ.
23/2 ಅಲ್ಲಿ ಅವರು 1 acre 29 ಗುಂಟಾಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ರಾಂಗ್ ಮೇಡಮ್.
ಎಷ್ಟಿದೆ?
ಅದು ಕಡಿಮೆ. 1 acre 21 ಗುಂಟಾಸ್.
ಅದಕ್ಕೆ ಏನು ಪ್ರೂಫ್ ಕೊಟ್ಟಿದ್ದೀರಾ? 1 acre
partition is madam. My father is partition equal share ಅಂತ ಹೇಳ್ತಾರೆ. ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಹೇಳೋದು?
23/4 ಒರಿಜಿನಲ್ ಸರ್ವೆ ನಂಬರ್ ಇದ್ದು 23 ಯಾವಾಗ ಆಯ್ತು? 23/1 23/2 ಅಂತ ಯಾವಾಗ ಆಯ್ತು?
ಬ್ರದರ್ಸ್ ನಂಜಣ್ಣ ನಾಗಣ್ಣ ಇಸ್ ಪಾರ್ಟಿಷನ್
ಯಾವಾಗ ಆಯ್ತು?
24/4/1990 ಅಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆದಾಗ then 24/1 and 24/2 ಅಂತ
ಎಷ್ಟೇ ಇಸ್ವಿ? Port agid yavaga? Yeng port aaytu? Was it based on your request? Port agide. Port agi khate agilva? Estne isvil khate bandide? No, 2 days time, Mr. Today. ನೋಡಿ ಸಾರಿ ಖಾತೆ ಯಾವ ಬಂತು ಅಂತ ಹೇಳ್ರಿ ನೋಡಿ ದಯವಿಟ್ಟು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವತ್ತು ಒಂದ್ ಸ್ವಲ್ಪ ಕೇಳೋದು ನಾಳೆ ಇನ್ನೊಂದ್ಸತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅದು ನಾಳೆ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಏನೋ ಕೇಳಿ ನಾಡಿದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅದು ಅದೆಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಟ್ಕೋಬೇಡಿ ಎಲ್ಲ ತಯಾರಾಗಿ ಬರ್ಬೇಕು ನೀವು ಎಸ್ ಗೊತ್ತಿಲ್ಲ ಕೋಡ್ ಯಾವಾಗ ಆಯ್ತು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಪಾಣಿ ಯಾವಾಗ ಬಂತು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಯಾವಾಗ ಆಯ್ತು ಪಾಣಿ ಬರ್ಕೊಳ್ಳಿ ಸಾರಿ This is an appeal filed by the defendants. You don't get many chances, Mr. Chance, one day chance. You will not get many chances. This appeal is filed by the defendants, challenging the concurrent finding of fact recorded by the Civil Judge Junior Division and Additional JMFC Tarikere in OS number 160 of 2003, which was confirmed by the First Appellate Court. Confirmed by the Senior Civil Judge and Principal JMFC Tarikere in RA 37 of 2007. Next para. The plaintiff, the suit in OS number 160 of 2003, the parties shall henceforth be referred to as they were arraigned before the trial court. The appellants herein were the defendants, while the respondents herein were the plaintiffs before the trial court. Next para. The suit in OS number 160 of 2003 was filed for declaration and possession, declaration of title and for recovery of possession of 12 guntas of land in survey number 23/2 of Sokke village, Ajjampura Hobli, Tarikere Taluk. Full stop. Next para. The plaintiffs claim that the land bearing survey number 23 of Sokke village was earlier owned and possessed by Puttappa, the proprietors of a joint family comprised of him and his two sons Naganna and Nanjappa. So after the death of Puttappa, both Naganna and Nanjappa divided the land bearing survey number 23 in terms of an unregistered partition, unregistered partition on 24/4/1990. Consequent to which the land in survey number 23 was bifurcated as survey number 23/1 and 23/2. To stop. The land in survey number 23/1 fell to the share of Yarge. Nagananga Nanjappa. Fell to the share of Nanjappa, while survey number 23/2 fell to the share of Naganna. To stop. The plaintiffs are the legal heirs of Naganna, while the defendants are the legal heirs of Nanjappa. To stop. The plaintiffs alleged that the defendants had encroached into 12 guntas of land in survey number 23/2 and hence filed a suit for declaration of their title and consequently for possession, for recovery of possession. This suit was contested by the defendants. One, two, three. Contested by the defendant number 4, who filed his written statement, and the defendants 1, 2, 3 adopted the same. The defendants admitted the relationship with the plaintiff, but and also admitted the partition dated 24/4/1919. They claimed that after the death of Nanjappa, they were in possession of half portion of survey number 23. With half portion survey number 23. So they alleged that the suit property claimed by the plaintiffs was portion of the land bearing survey number 23/4, and that their father had mortgaged the said property to Patel Mallappa. They also contended that survey number 23/4 belonged to was their ancestral property. To stop. They disputed the extent of land available in survey number 23/2 as claimed by the plaintiffs. To stop. Based on these rival contentions, the trial court framed the following issues. The legal representative, first of during the pendency of the suit, the plaintiff died and his legal representatives were brought on record. The legal representative number 2 was examined as PW1, who marked exhibits P1 to P12 and examined a witness as PW2. On the other hand, the defendant number 4 was examined as DW1 and he marked exhibits D1 to D17 and examined a witness as DW2 to stop. The trial court appointed a commissioner to inspect the spot to stop. He was examined before the court as CW1 and he marked documents exhibits C1 to C5. Next paragraph. Based on the oral and documentary evidence, the trial court held that the ownership of the predecessors of the plaintiffs and defendants in respect of survey number 23 was admitted, and it is also admitted that the said property was partitioned between the members of the family. The trial court noticed that survey number 23 was resurveyed and subdivided into survey number 23/1, 23/2, 23/3, and 23/4. Full stop. While survey number 23/2 measured 1 acre 30 guntas, including 1 gunta of Karab, survey number 23/1 measured 1 acre 15 guntas, and survey number 23/4 measured 15 guntas.
Other property.
Who is PW2 here? Surveyor, right?
No, man. CW2 is
CW2.
surveyor. PW is who is the witness?
Yaar witnesses.
Thank you.
ಹೌದ್ರಿ PW2 ಅಂದ್ರೆ plaintiff witness ರೀ Mr. Who is he? Is he a surveyor, private surveyor?
No, surveyor is the CW1 Shivappa is the surveyor. Attested land owner.
Please come to page number 51. 51 ಬನ್ನಿ. On the other hand, PW2 in his cross-examination specifically stated, so and so, so and so. He stated the defendant's lands are situated towards southern and western side of property. He denied that he has not inspected the spot and not measured. Yaru, who is PW2 then? What is this, mister?
ಪಾರ್ಟಿ ಒಪ್ಪಿಗೆ ಸರಿ ಆಗಬೇಕು ನಮಗೆ ನೋಟಿಸ್ತೀವಿ ಸ್ಥಳಕ್ಕೆ ಬಂದಿರ್ತಾರೆ ಎಂದರೆ ಸರಿ ಅಳತೆ ಸಮಿತಿ ನಾವು ಆಚರಿಸಬೇಕು.
Property was there between the partition between the family. The third court notice 723. So they surveyed and divided into 723/1 to 23/4.
Stop. It also noticed from the evidence on record that the suit property lay on the northern side of survey number 23/4. The trial court had taken the assistance of a commissioner who visited the spot and prepared a report indicating that the defendants had encroached into an area measuring 12 guntas in survey number 23/2. Stop. The trial court also noticed that notice from trial court notice from the RTC extracts at exhibit P1, P2, P10, exhibit D2 and D2, D3, D13 to 16. That survey number 23/1 measured 1 acre 15 guntas, while survey number 23/2 measured 1 acre 30 guntas, and 23/3 measured 3 acres, and 23/4 measured 15 guntas. The trial court held from the evidence on record, the defendants were in possession of survey number 23/1 and survey number 23/4. And that the claim of the defendants that the suit property forms part of survey number 23/4 was derived from the statement that it lay beyond survey number 23/4. Full stop. The trial court therefore held that the defendants had encroached into the suit property and hence decreed the suit and directed the defendants to put and deliver vacant possession of the encroached area to the plaintiffs. Next paragraph. Feeling reviewed by the aforesaid judgment and decree, the defendants filed RA 37 of 2007. So the first appellate court secured the records of the trial court, heard the counsel for the parties and framed the points for consideration, and taking into account the oral and documentary evidence, held that the defendants had encroached into 12 guntas of land in survey number 23/2 and thus dismiss the appeal. Being agreed by the aforesaid concurrent finding of fact, the present regular second appeal is filed. Next, by learned counsel for the defendants submitted that the property claimed by the plaintiffs was in fact the property lying in survey number 23/4, and therefore, the plaintiffs were not entitled to any relief. However, the learned counsel did not dispute the fact that the plaintiffs were allotted survey number 23/2, where the defendants did not have any right, title, or interest. Full stop. If the defendants do not have any manner of right, title, or interest in survey number 23/1, they cannot complain against decreeing the suit filed by the plaintiffs. Full stop. Even otherwise, the trial court as well as the first appellate court has considered the oral and documentary evidence in proper perspective and have concurrently held that the defendants had unauthorizedly encroached into the suit property and hence decreed the suit. This court does not feel it appropriate, does not consider it appropriate to disturb the finding of fact recorded by both the courts, as there is no substantial question of law which arises for consideration in this appeal. ಏನ್ ಡಿಲೇ ಇಲ್ಲ. 83 ಇಯರ್ ನೀವು ಯಾವಾಗ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ರಿ ಅಂತ ಏನು ಹೇಳಿದ್ರಾ? ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ರೆಡಿಯಾಗಿ ಬನ್ನಿ. ಡೋಂಟ್ ಕಮ್ ಹಾಫ್ ಹಾರ್ಟೆಡ್ಲಿ ರೆಡಿಯಾಗಿ ಅರ್ಧಂಬರ್ಧ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಡಿ. The mediation report failed. Mr. Sachin BS. Mr. Sachin BS, pass over. K. Anandarama. Pass over. Mr. Sidmalappa.
Please, my lord.
T.R. Basavarajappa.
Third defendant's appeal.
Yes.
Suit for partition.
Yes.
Lord Rangappa is the father. Lord Rangappa, Lord died. Rangappa and his wife Ningamma.
Yes.
Died leaving behind 7 children. Lord, the
7 or 8.
Sorry.
8 jana. Lakkama, Nagamma, Channappa,
8 jana. I'm sorry, 8 jana. Page number 59, sir.
Yes.
8 jana. Gauramma, the appellant is not the daughter.
Yes.
Lord, the claim, Lord, the suit was filed only with respect to one item of the property, leaving other items of the property owned by the family.
Who is this Channappa? Plaintiff.
Plaintiff is the first respondent.
Sir, plaintiff is the first respondent. I understand. Genealogical tree plaintiff ಎಲ್ಲಿದ್ದಾರೆ?
ಮೂರನೇವರು.
ಯಾರು? ಚೆನ್ನಪ್ಪ.
ಹೌದು.
Who are these other defendants? Siddhappa is the other son.
Lord, the
Rajappa is this. Gauramma. Gauramma ಇಲ್ಲಿ. Sharadamma. Who is Sharadamma? So Rajappan ಹೆಂಡತಿ. Chandrappa. Maheshwarappa.
Is the
Manjappa.
ಅದರಲ್ಲಿ 7th ಡಿಪೆಂಡೆಂಟ್ ಒಬ್ರಿಲ್ಲ ಅವರು he died without not living any legal representatives.
Manjappana.
ಅಲ್ಲ ಪ್ರಭು ಅಂತ. Prabhu.
Yes,
Not the suit is filed only with respect to one item of the suit property, that is land bearing survey number 13/15, measuring 1 acre of Giriyapura village.
Yes.
Lord, the claim of the plaintiff is that Lord, this property is granted in the name of the father. And after his death, Lord, the property was not subject matter of partition. And Lord, defense taken by the third defendant is that Lord, there is a will in respect of this property, a registered will. Lord, the registered will dated 3/5/2005, executed by the mother. And the other defense is that Lord, partial partition cannot be Lord allowed.
Yes.
He admits about the existence of the property.
Which are the other properties?
Which property descriptions are Lord that can be Lord referred by the trial court. Lord, that can be seen at paragraph 38, Lord. Paragraph 38.
Paragraph 38.
38 of the trial court judgment. Internal page 21, running page 52. Can I read, Lord?
Yes.
The defendant number 3 and 9 stated that the plaintiff has not included all joint family property. The properties bearing survey number 13/16 measures 1 acre stands in the name of Channappa. Survey number 13 measures 19 acres 3 guntas, out of which 30 guntas stands in the name of Krishnappa. 30 gunta stands in the name of Srimati Rangamma. 25 gunta stands in the name of Rajappa. Survey number 13/22, 30 gunta in the name of Siddhappa are all also joint family property. The defendant number 3 has produced exhibit D 16 to 19 to show that the properties have stands in the name of above mentioned person. But in column number 10 of the RTC, shown that the lands have been granted on 5/7/2005 and but condition that they shall not alienate the property for 15 years. In the cross-examination of PW1, it is suggested that by granting suitshare property to Rangappa, the land has been granted to the wife of plaintiff. But defendant number 3 has not proved at the time of granting suitshare property to her father, some bit of land were granted to wife of plaintiff and defendant number 1 and 2. The plaintiff has stated that after came out from the joint family, land has been granted to his wife by government. The defendant number 3 has not proved that the properties mentioned in para 14 of the additional written statement are also joint family properties of plaintiff and defendants. Further, there is no documentary or oral evidence to prove that those lands were granted to plaintiff and defendant 1 and 2 when they were residing in the joint family. In the written statement filed by the 9 defendants stated that those properties were also put into the joint family hodgepodge, and neither defendant 3 or defendant number 9 proves that same. That is not the admittedly property is available. Admittedly, plaintiff says that the joint family is existing and he seeks partition.
Yes.
Not under these circumstances, not the other admissions. Not,
is it not for you to prove before the court that these properties are available for partition?
Lord, I have produced the RTC. Except RTC, I can't have other document to produce to refer those properties are belong to the family, but it stands in the name of family members.
Oh, that
I
is
proved
right.
that.
No, but how do you prove that the property was purchased out of the assets of the joint family?
No, it is not the purchase, it is a grant.
It's a grant agli. How do you prove yavat grant ಆಯ್ತು ಹೆಂಗ್ grant
ಅದೇ
ಆಯ್ತು?
ಡೇಟ್ ಹೇಳಿದೀನಿ, ಅಪ್ಪನಿಗೆ ಯಾವತ್ತು ಗ್ರಾಂಟ್ ಆಯ್ತು ಎಲ್ಲರಿಗೂ ಅವತ್ತೇ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
ಯಾವ ಅಪ್ಪನಿಗೆ?
2000 ಫಾದರ್ಗೆ ಯಾವತ್ತು ಗ್ರಾಂಟ್ ಆಯ್ತು ಸೂಟ್ ಶೀಟ್ ಪ್ರಾಪರ್ಟಿ, ಅದೇ ದಿವಸ ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಮಿಕ್ಕಿದ್ದ ಎಲ್ಲ ಅದರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಆಲ್ಸೋ ಗಾಟ್ ಗ್ರಾಂಟ್.
What is the evidence adduced for you to show?
No, I have produced the document exhibit 16 to 19.
Those are the RTC extracts. Everybody accepts that these lands exist.
Lord,
But
they
how-
are saying,
how have you-
no. My submission is plaintiff approached the court. Plaintiff admits that property stands in the name of other members of the family. Then they have not even produced any document to show that grant is independently made.
Yes, let us see the issues that are framed.
Running page 41, internal page 10.
Yes, who appears? Where is the issue regarding partial partition, Mr. Partial partition ಬಗ್ಗೆ issue ಎಲ್ಲಿದೆ? ಮತ್ತೆ ಇಲ್ಲದೆ ಇದ್ರೆ ಎವಿಡೆನ್ಸ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ?
Regarding that survey number is concerned. Whereas I left the family blood in the year 1975. Did not dispute. Second defendant.
Not dispute, and who has not disputed?
Other side. Other side. Second defendant left it in 1980. This is the land granted Malad in favor of my father. After that, after the demise of my father, and the property is been made in favor of my mother. My mother is in position of the defendant number 3, she got a will. That court come to confirm that will, there is a suspicion created in the will. And even the witness and the document writer, there is a discrepancy in the evidence.
Have you disputed that he is separated from the family in 1975?
No. He claimed that father died about 25 years back.
Have you disputed that the plaintiff had separated from the family in the year 1975?
No, I never disputed.
You do not dispute. Then when was the land granted in his name?
Lord, the suit sheet property and other properties of the same survey number were granted, Lord, on the same day.
What is that same day? ಅದಕ್ಕೊಂದು ಡೇಟ್ ಇರಬೇಕಲ್ವಾ?
Lord, ಅದು ಅಲ್ಲಿ ಡೇಟ್ ನಾವು ರೆಫರ್ ಮಾಡ್ತಾರೆ. I read that portion. Swami.
In 2006.
5/7/2005.
So if
the RTC refers.
If he is separated in the year 1975, if
ಇಲ್ಲ,
some land is
separate ಆಗಿದೀವಿ ಅಂತ ಇಲ್ಲ, ನಂದಲ್ಲ ಕಂಟೆನ್ಷನ್. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, they are saying father died about 25 years back to the date of suit and mother died subsequently, and they claims after lapse of 25 years they claim that property belongs to the father.
I am sorry you have not read the papers then. Please read the judgment of the trial court. Second page number 12 nodi, second line. During the lifetime of Rangappa, plaintiff came out of the family due to differences of opinion and started residing.
No, I never said it. Partition agide antella. They started residing separately.
So therefore, what is there to show that this man was getting income from the joint family to pay the premium for allotment of this land or for grant of this land?
Lord, he is claiming that property is granted in their name. It is burden on him to say independently that was granted.
It's for you to prove that it was out of the joint family nucleus or it was thrown into the common hotspot.
Lord, his own case is that not suit sheet property in the joint position.
Yes.
He claims suit sheet property is in joint position and they continue to be in joint seeking not partition.
Yes, Astena. Anything else?
Lord, just I want to, Lord, I may permitted to, Lord, refer, Lord, the way in which the pleadings are played by the
Yes.
plaintiff. Lord,
Yes.
the claim of the plaintiff, Lord, he doesn't refer, Lord, the date of grant of suitship property in favor of the father. Lord, you will ask me
That is
kindly
this-
see, Lord, the document produced.
Yes. Certified copy of the grant certificate.
Grant certificate. Lord, that endorsement, RTC extract. Lord, the date of grant, Lord, the grant certificate refers to '77-78. That is 10/5/1978.
Yes.
Lord, this date is taken into consideration. On that day, father and children are together.
Yes.
Lord, they continued. He never, Lord, claimed that there is a partition or severance in the family.
Yes.
Lord, for the benefit of the suit share property, he claimed joint position and subsistence of the joint family.
Yes.
For the purpose of having defense to the other properties are concerned, Lord, he refers to my statement saying that we are all not together. We started living separately. I never said there is a division in the family.
Yes.
And date of death of the father, no division.
Yes.
Property, Lord, stands in the name of mother, is the subject matter of the registered will. They have not challenged the will.
Will challenge Manadin, but the will is executed by the mother, not the father.
No. Lord, my case is, Lord, grant is in the name of mother.
Grant is in the name of the mother.
My case is grant made in the name of mother. Documentation was taken in the name of father.
Adingagutte, sir.
ಅಲ್ಲ ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಹೆಂಗಾಗತ್ತೆ ಇಲ್ಲ ನಾನು just I can refer.
The 1978 document, now we want to say that it was ostensibly granted in the name of the father.
No, as on the day when the grant was made, he was holding property. He was not the eligible person for grant of any land.
Why was it granted in his name?
The grant order not in the name of mother, and the revenue records were taken in the name of father.
Where is the grant order? Exhibit P1 ಎಲ್ಲಿದೆ? P1 ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
ಅಲ್ಲ, P1 grant certificate of the grant ಅದು. Grant order produce ಮಾಡಲಿಲ್ಲ ಅವರು.
ಆಯ್ತು, grant certificate ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
ನಾನು I can refer not the grant certificate.
Yes, please. Somebody answer this question.
Not it says Sri Rajappa.
Rajappa is the father.
And son of Rangappa.
So therefore grant is made in the name of the father. Where is the question of mother executing a will?
Rangappa is the father. Rangappa is the father. Rajappa is not the father.
Whatever. Rangappa is the father.
Rangappa is the father. The grant certificate I am holding, Lord, here. Lord, it refers to the name of Sri Rajappa, son of Rangappa.
Rajappangu on the land grant aitu, sir.
Sri Krishnappa, son of Siddhappa.
Exhibit P1 idya. Krishnappangu grant agide, Rajappangu grant agide, Rangamman grant agide, Channappan grant agide.
ಹೌದು. ನಾ ಕೇಳ್ತಾ ಇರೋದು ಏನಿದೆ,
I am asking you about exhibit P1, sir. Kindly help me with exhibit P1. P1 ಅಲ್ಲಿ ಯಾರ ಹೆಸರು ಇದೆ?
I'm sorry. Not I'm getting that document. Lord, I'm getting that document. Lord, it stands in the name of Rangappa only.
All right, I will. Stands in the name of Rangappa.
Rangappa, son of Channappa.
Then how can the mother execute a will?
Lord, it is after the death of father, mother executes. Lord, then even apportionating 1/8 share is also Lord defective.
Yes.
If the property inherited by Lord all 8 children and mother,
yes,
plaintiff get only 1/9 share.
So let us see about evidence of PW1 about these properties.
Please.
Cross examination.
Can I read, Mullah?
Yes, please.
ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2 ನನ್ನ ಸ್ವಂತ ತಮ್ಮಂದಿರು. ನನ್ನ ತಾಯಿ ಜೀವಂತ ಇರುವವರೆಗೂ ಎಲ್ಲರನ್ನೂ ಸಮನಾಗಿಯೇ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ನನ್ನ ತಾಯಿಗೆ ಗಂಡು ಮಕ್ಕಳು ಹೆಣ್ಣು ಮಕ್ಕಳು ಎಂಬ ತಾರತಮ್ಯ ಇರಲಿಲ್ಲ. ನನ್ನ ತಾಯಿಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಇಲ್ಲ. ನಾನು ದಾವಾ ಆಸ್ತಿಯ ಬಗ್ಗೆ ನಮ್ಮ ತಂದೆ ಯಾವುದೇ ದಾಖಲೆ ಬರೆದುಕೊಟ್ಟಿಲ್ಲ. ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2 ಭಾಗ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ತಂದೆ ರಂಗಪ್ಪ ಕಾಲವಾಗಿ 15-16 ವರ್ಷ ಆಗಿರುತ್ತದೆ. 3ನೇ ಪ್ರತಿವಾದಿಗೆ ಅಂದಾಜು 11 ವರ್ಷ ಪ್ರಾಯ ಇದ್ದಾಗ ನನ್ನ ತಂದೆ ತೀರಿಕೊಂಡಿದ್ದಾರೆ. ಆ ಕಾಲಕ್ಕೆ ನಾನು ಬೇರೆ ಇದ್ದೆ. ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2 ಜೊತೆಯಲ್ಲಿ ಇದ್ದರು. ಗಿರಿಯಾಪುರದಲ್ಲಿ ಒಂದು ಕೊಟ್ಟಿಗೆ ಕಟ್ಟಿಕೊಂಡು ಪ್ರತ್ಯೇಕ ವಾಸ ಇದ್ದೆ. ಈ ರೀತಿ ನಾನು ಪ್ರತ್ಯೇಕವಾಗಿ ಇದ್ದು 40 ವರ್ಷ ಆಗಿರುತ್ತದೆ. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ತಂದೆ ದಾವಾ ಆಸ್ತಿಯ ಸರ್ವೆ ನಂಬರಿನಲ್ಲಿ 16ನೇ ಪೋಡಿನಲ್ಲಿ 1 ಎಕರೆ ನನ್ನ ಹೆಸರಿಗೆ ಮಂಜೂರು ಮಾಡಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅದು ಮಂಜೂರಾಗಿ 30-35 ವರ್ಷಕ್ಕೂ ಹೆಚ್ಚಿಗೆ ಆಗಿದೆ. ಸದರಿ ಜಮೀನನ್ನು ನಾನು ಒಬ್ಬನೇ ಪ್ರತ್ಯೇಕ ಸ್ವಾಧೀನ ಹೊಂದಿದ್ದೇನೆ. ಹೆಣ್ಣು ಮಕ್ಕಳಿಂದ ಸರಿಬರದೇ ಇದ್ದ ಕಾರಣ ಪ್ರತ್ಯೇಕ ವಾಸ ಇದ್ದೇನೆ. ನಾನು ಪ್ರತ್ಯೇಕವಾದ ಇರಲು ಪ್ರಾರಂಭಿಸಿದ ನಂತರವೇ ಲಕ್ಷ್ಮಮ್ಮ, ಚಂದ್ರಮ್ಮ 3ನೇ ಪ್ರತಿವಾದಿಯ ಮದುವೆಗಳು ಆಗಿವೆ. ನನ್ನ ತಾಯಿ ಸಾಯುವವರೆಗೂ 3ನೇ ಪ್ರತಿವಾದಿಯ ಜೊತೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದಳು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಗಿರಿಯಾಪುರದಲ್ಲಿ 2ನೇ ಪ್ರತಿವಾದಿಯ ಜೊತೆ ಇದ್ದಳು. ನಾನು ಬೇರೆಯಾದ 6 ವರ್ಷಗಳಿಗೆ ಪ್ರತಿವಾದಿ 1, 2 ಸಹ ಬೇರೆಯಾಗಿದ್ದಾರೆ. ಅವರಿಬ್ಬರು ಗಿರಿಯಾಪುರದಲ್ಲಿಯೇ ವಾಸ ಇದ್ದಾರೆ. ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2 ಪ್ರತ್ಯೇಕ 1 ಎಕರೆ ದಾವಾ ಸರ್ವೆ ನಂಬರಲ್ಲಿ ಮಂಜೂರು ಆಗಿದೆ ಎಂದರೆ ಕೇವಲ ಅರ್ಧ ಎಕರೆಯಂತೆ ಆಗಿರುತ್ತದೆ ಎಂದು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಾರೆ. ಪ್ರತಿವಾದಿಯವರು ತಮಗೆ ಮಂಜೂರಾದ ಜಮೀನನ್ನು ಬೇರೆಯವರಾಗಿನಿಂದ ಪ್ರತ್ಯೇಕ ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2 ರವರು ಬೇರೆಯಾಗುವ ಕಾಲಕ್ಕೆ ಲಕ್ಷ್ಮಮ್ಮ ಮಾತ್ರ ಮದುವೆಯಾಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. 3 ಮದುವೆಯಾಗಿತ್ತು. ಅಂದಾಜು 30 ವರ್ಷದ ಕೆಳಗೆ ಜಮೀನು ನನ್ನ ಹೆಸರಿಗೆ ಮಂಜೂರು ಆಗಿದೆ. ಅರ್ಜಿಯನ್ನು ನಾನೇ ಕೊಟ್ಟಿದ್ದೇನೆ. ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2 ಸಹ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರು. ನನ್ನ ತಾಯಿ ನಿಂಗಮ್ಮ ತ್ಯಾವಣಿಗೆಯಲ್ಲಿ ಮೃತಪಟ್ಟಿದ್ದಾರೆ. ದಿನಾಂಕ ಗೊತ್ತಿಲ್ಲ. ಶವ ಸಂಸ್ಕಾರಕ್ಕೆ ಸಹ ನಾನು ಬಂದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನೇ ಮಾಡಿದ್ದೇನೆ. 3ನೇ ಪ್ರತಿವಾದಿ ಮನೆಯಲ್ಲಿ ನನ್ನ ತಾಯಿಯು ಮೃತಪಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ತಾಯಿ ಸಾಯುವ ಕಾಲಕ್ಕೆ 80 ವರ್ಷ ಆಗಿತ್ತು. ನಾನು ಪ್ರತ್ಯೇಕಿಯಾದ ನಂತರ ನನಗೂ 3ನೇ ಪ್ರತಿವಾದಿಗೂ ಮತ್ತು ನನ್ನ ತಾಯಿಗೂ ಒಡನಾಟ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಾಯಿ ನನ್ನ ತಮ್ಮನ ಜೊತೆ ಇದ್ದಳು. ರಾಜಪ್ಪನ ಜೊತೆ ಇದ್ದಳು. ನನ್ನ ತಾಯಿ ಯಾವ ವರ್ಷದಿಂದ ಯಾವ ವರ್ಷದವರೆಗೆ ಆತನ ಜೊತೆಯಲ್ಲಿ ಇದ್ದಳೆಂದು ಹೇಳಲು ನನಗೆ ಆಗುವುದಿಲ್ಲ. ನನ್ನ ತಾಯಿ ಇಂದಿಗೂ 1.5 ವರ್ಷದ ಹಿಂದೆ ಗಿರಿಯಾಪುರದಿಂದ ನ್ಯಾಮತಿಗೆ ಹೋಗಿದ್ದಾರೆ. ರಾಜಪ್ಪನ ಮನೆಯಲ್ಲಿ ಪಡಿತರ ಚೀಟಿ ಇರುತ್ತದೆ. ಪಡಿತರ ಚೀಟಿಯಲ್ಲಿ ಯಾವೆಲ್ಲ ವಾಸ ಇದ್ದಾರೋ ಅವರ ಹೆಸರನ್ನು ಬರೆಯುತ್ತಾರೆ. ಅದೇ ರೀತಿ ಮತದಾರರ ಯಾರು ಎಲ್ಲಿಯೂ ಬರೆಯುತ್ತಾರೆ. ನನ್ನ ತಾಯಿ 3ನೇ ಪ್ರತಿವಾದಿಗೆ ಮದುವೆಯಾದ ದಿನದಿಂದ ಆಕೆಯ ಜೊತೆ ತ್ಯಾಮಿಗೆಯಲ್ಲಿ ತ್ಯಾಮಿಗೆಯಲ್ಲಿಯೇ ವಾಸ ಇದ್ದಳು ಎಂದರೆ ಸರಿಯಲ್ಲ. 3ನೇ ಪ್ರತಿವಾದಿಗೆ ನನ್ನ ತಾಯಿಯ ಆರೈಕೆ ಮಾಡುತ್ತಿದ್ದಳು ಮತ್ತು ಆಶ್ರಯ ಕೊಟ್ಟಿದ್ದಳು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಾಯಿ ನನ್ನ ಮತ್ತು ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2ರವರ ಮನೆಗೆ ಎಂದಿಗೂ ಬಂದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಂದಾಜು 4 ವರ್ಷದ ಹಿಂದೆ 3ನೇ ಪ್ರತಿವಾದಿ 2ನೇ ಪ್ರತಿವಾದಿ ಮನೆಯಿಂದ ಪಡಿತರ ಚೀಟಿ, ಮತದಾರರ ಪಟ್ಟಿ ಮತ್ತು ಇತರೆ ಕೆಲವು ದಾಖಲೆಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿದ್ದಾಳೆ. 2ನೇ ಪ್ರತಿವಾದಿಯೇ ಸದರಿ ವಿಷಯ ನನಗೆ ತಿಳಿಸಿದರು. ನಾನು ರಾಜಪ್ಪ ಚೆನ್ನಾಗಿಯೇ ಇದ್ದೇವೆ, ಲಕ್ಷ್ಮಮ್ಮ ಜೀವಂತ ಇದ್ದಾರೆ. ಅಂದಾಗೆ ಆಕೆ ಗಿರಿಯಾಪುರದಲ್ಲೇ ಇದ್ದಾಳೆ. ಚಂದ್ರಮ್ಮ ಇನ್ನೊಬ್ಬ ತಂಗಿ ಕಾಲವಾಗಿದ್ದಾರೆ. ಆಕೆಗೆ 1 ಹೆಣ್ಣು ಮಗು, ಗಂಡು ಮಗು. ಮಗನ ಹೆಸರು ನಿಂಗಪ್ಪ, ಮಗಳು ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ನಿಂಗಪ್ಪ ಗಿಡದ ಹಳ್ಳಿಯಲ್ಲಿ ಇದ್ದಾರೆ, ಮಗಳು ದಾವಣಗೆರೆಯಲ್ಲಿದ್ದಾರೆ. ಈ ದಾವೆ ಹಾಕುವ ಮೊದಲು ನಾವು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನು ಮತ್ತು ಪ್ರತಿವಾದಿ 1-2 ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಜಮೀನುಗಳು ಈ ದಾವೆಯಲ್ಲಿ ಸೇರಿಸಿಲ್ಲ. ದಾಖಲೆ ವಕೀಲರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಮ್ಮ ಆಸ್ತಿಗಳಲ್ಲಿ ಯಾವುದೇ ಭಾಗ ಆಗಬೇಕಾಗಿರುವುದಿಲ್ಲ. ನಮ್ಮ ತಂದೆ ಸತ್ತ ಕಾರಣ ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ ಪಾಲು ಬರಬೇಕಿರುತ್ತದೆ. ನನ್ನ ತಂದೆ ತಾಯಿಗೆ 1ನೇ ಮಗ, ನನಗೆ 2 ತಮ್ಮಂದಿರು, ಅಕ್ಕ ತಂಗಿಯರು 5 ಜನ. ಸಿದ್ದಪ್ಪ ಮತ್ತು ರಾಜಪ್ಪ ತಮ್ಮಂದಿರು. ಲಕ್ಷ್ಮಮ್ಮ, ನಾಗಮ್ಮ, ಚಂದ್ರಮ್ಮ, ರಂಗಮ್ಮ, ಗೌರಮ್ಮ ನನ್ನ ಸಹೋದರಿಯರು. ಗೌರಮ್ಮಳನ್ನು ಹೊರತುಪಡಿಸಿ ಇತರೆ ಸಹೋದರಿಯರು ಮೃತಪಟ್ಟಿದ್ದಾರೆ. 4 ಜನ ಸಹೋದರಿಯರಿಗೆ ವಾರಸುದಾರರು ಇದ್ದಾರೆ. ಸಾಕ್ಷಿ ಪುನಃ ನುಡಿಯುತ್ತಾರೆ. ನಾಗಮ್ಮಳಿಗೆ ಸಂತಾನ ಇಲ್ಲ. ಗಂಗಮ್ಮಳಿಗೆ 1 ಹೆಣ್ಣು 1 ಗಂಡು ಮಗ. ಚಂದ್ರಮಳಿಗೂ 1 ಹೆಣ್ಣು ಮಗು ಗಂಡು. ಲಕ್ಷ್ಮಮ್ಮಳಿಗೆ 3 ಜನ ಗಂಡು ಮಕ್ಕಳು, 1 ಹೆಣ್ಣು ಮಗಳು. ನನ್ನ ಸಹೋದರಿಯರು ಮದುವೆಯ ನಂತರ
What is the I sought for the date of 1 of after the macros evidence and others comes on record also. The lottery condition page 21 of the
What about partial partition? There is no issue. There is no issue. And
but however, my lord, the point raised by the defendants, my lord, or discussed by the court, and there is no whisper, my lord, they not made any application for amendment of the additional issues also.
Yes.
It is not prevented them. When they lost in the suit also, and I suit was succeeded there. They come there before the appeal, they not raise that ground also.
When was this land granted to you? When was this 1 acre of land granted to you? And
granted to my wife, but not wife.
in your name 1 acre. There is 1 acre of land granted to you. 30 guntas of land is granted to your wife's name under the same grant in the year 1978. In ತಂದೆ ಗ್ರಾಂಟ್ ಆಗುವಾಗ್ಲೇನೆ ನಿಮಗೂ ಮತ್ತೆ ನಿಮ್ಮ ಮಿಸ್ಸಸ್ಗೂ ಗ್ರಾಂಟ್ ಆಗಿದೆ. And all these properties are in the same survey number. ಅಕ್ಕಪಕ್ಕದ್ದು
ಅಲ್ಲ, ಒಂದೇ ಸರ್ವೆ ನಂಬರ್.
ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಅಂದ್ರೆ ಒಂದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ವಾ?
ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್, ಡಿಫರೆಂಟ್ ಪೋರ್ಷನ್ಸ್.
ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ ಅಂದ್ರೆ ಒಂದೇ ಸರ್ವೆ ನಂಬರ್ ಇನ್ ಕನ್ನಡದಲ್ಲಿ.
ಪ್ಲೀಸ್.
So how do you say that that was your independent property?
Individually, it has been granted in my favor.
Usually, no doubt. Question is whether
The government land is granted in my favor.
we are talking of 1978. We are talking of 1978. What is there to show that you are living separately from 1975?
My statement also made in the amendments in the blind. It is not disputed manner by other
Let
side.
us see. Let us see the
My
written
great
statement.
manner.
Let us see the written statement.
Dr. Rangappa, son of Chennappa,
Yes. That is denied. That you are separately residing in this property is denied. Only D3 filed the written statement. Is it? Deny ಮಾಡಿದಾರಲ್ಲ.
evidence also.
Sir, deny ಮಾಡಿದ್ರೆ prove ಯಾರು ಮಾಡಬೇಕು ಸರ್? Deny ಮಾಡಿದ್ರೆ prove ಯಾರು ಮಾಡಬೇಕು? Plaintiff should not.
Come before the court, madam, we have to prove it, madam, also. It is not dispute, madam, it can be is concerned.
No, perfect. The substantial question of law which arises for consideration in this appeal is whether the trial court and the first appellate court lost sight of the fact that the defendant number 3 had categorically contended that the plaintiff had not included the lands granted to him and his wife in the suit for partition, and thereby erred in not framing an issue to that effect. Next, whether the trial court and the first appellate court failed to consider that the property that stood in the name of the plaintiff and his wife were properties belonging to the joint family, to his wife as well as
Brother Chandra.
defendant number 2 and
Defendant number 3. 2 and 3.
3 ಹೆಸರಿಗೂ ಗ್ರಾಂಟ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಕೃಷ್ಣಪ್ಪ ಯಾರು? Krishnappa, who is Krishnappa?
Krishnappa is not the family member. He is different. Lord, in his evidence, he admits that his brother also benefited with the grant.
Siddhappa yaru? Different number 1 and 2.
Siddhappa, my lord, one of the son. ಇದರಲ್ಲಿ ವಂಶವೃಕ್ಷದಲ್ಲಿ 4ನೇ ಅವರು. 4ನೇ.
1 and 2 were the properties of the joint family. Having regard to the fact that they are all granted on the same date, when the suit property was granted in the name of their father.
Lord, I filed application, Lord, stay up, Lord, final decree proceeding.
Filed up a final decree, state, until disposal of this appeal. Yes, next. This is an urgent item. Yes.
Concurrent finding. Only one point with regard to gift.
Yes.
In that, whether that gift is discloses only one person, that is first defendant, or his mother and also father. That is the question, my lord.
What are the facts?
That is
What are the facts?
facts that appellate hearing by a suit claiming that it is ancestral property. As such, I am entitled to have one share, one sixth share. That court below, while passing judgment, contended that he has not produced any document to show that it is ancestral property. Thereafter, filed the appeal. Appeal also is confirmed by upholding the observation of the court below. So my question is, this is the whole property, whole claim by both the parties is depending on the 50. That is exhibit B1. That B1 exhibit, that is maternal father gifted the property only for defendant number 1 or his daughter and also son. That is the percent that the court below not taken into the account. Yes. That's all my case. If that is proved, I don't know. This whole case is depending on that.
You're not giving the facts properly. Who's fifth defendant? Fifth defendant here.
So later what happened? So they are admitting as far as plaintiff and defendant 1 to 6 is concerned, they are the children of Super Shakti. And subsequently they sold this property to defendant number 5 and 6. That is at present number 2 and 3.
So the trial court did caste is Tikanagi. The plaintiff and the appellant to the. So therefore, I've been telling everybody, please stick to the trial court caste. How many times should I tell? Trial court caste is Tikanagi. The plaintiff and the appellant and the respondent.
Plaintiff number 1 to 6 are there. Defendant number 1 to 3 are there.
Different number, plaintiff number 1 to 6 are the brothers.
And also defendant number 1.
Yes, different number is also the brother. What is the suit property?
Suit property. That is agricultural land, 3 acres, 6 acres, and 2 house property.
Yes, 1 landed property and 2 house properties. Item number 1, Yarisla Ligidu.
Item number 1, according to them, it is Mr. Ramchandra.
Them and according to them and whom?
No, according to Mr. Ramchandra, defendant number 1.
Good. Yarisla with the defendant 1.
Ramchandra, that is, he is telling the property gifted to him.
So
by maternal father.
By maternal father.
But the gift is clearly establishes that has been gifted to mother, daughter, son-in-law, and grandson. That is given number 1. Subsequently, what happened, my lord?
What about the other 2 properties?
That is the old property that subsequently they have increased. First the suit filed under a dealer. Subsequently, other shares in the market.
Yeah, share it, sir.
Federal property owns to A and B. It belongs to that is they acquired 2 gifts. There are 2 gifts.
The ಮನೆಗಳು ಯಾರಿಗೆ ಬಂತು? 2 property house properties ಯಾರಿಗೆ ಹೋಯ್ತು?
ಅದು ರಾಮಚಂದ್ರ ಹೆಸರಿಗೆ ಅಂತ ಅವ್ರು ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ.
ನಿಮ್ಮ ಪ್ರಕಾರ ಏನು?
ಪ್ರಕಾರ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ the property gifted by that is Rama Shetty, first defendant grandfather, maternal father, he gifted in favor of son-in-law and daughter.
ಅದು ಅರ್ಥ ಆಯ್ತು. ಐಟಮ್ ನಂಬರ್ 1 ನಂಗೆ ಅರ್ಥ ಆಯ್ತು ಸರ್. ಐಟಮ್ ನಂಬರ್ 2 and 3.
There is 2 gifts. Exhibit B1 and B2.
Yes. So ಎರಡು D2 ನಲ್ಲಿ 2 ಮನೆ ಕೊಟ್ರಾ?
D2 ನಲ್ಲಿ 1 ಮನೆ.
D2 ನಲ್ಲಿ 1 ಮನೆ ಇದೆ. ಇನ್ನೊಂದು ಮನೆ?
ಇನ್ನೊಂದು ಮನೆ ಇವರು ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ. ಇವ್ರ ಫಾದರ್ ಎಲ್ಲ.
ಇವರು ಅಂದ್ರೆ ಯಾರು ಸರ್?
ಇವರು ಅಂದ್ರೆ ಫಾದರ್ ಇಲ್ಲ. ರೈಟ್.
Yes.
So they are not disputed as far as relationships is concerned. And what happened, my lord? Here, by selling the property to different number 2 and 3, all the persons except the plaintiff number 1
sold the property or executed as trading. My submission is, my lord, if this property is declared only for given number one, what made them to execute this deed by other children, including mother? It 2 to 6 and also different number 1.
Yes.
That is the reason all property belongs to family.
Yes, first time, purple. This appeal is filed by the unsuccessful plaintiffs. Invoice number 492 of 2006, challenging the judgment and decree dated 23/1/2016, by which the suit filed by the plaintiffs was dismissed. Stop. Suit filed by the plaintiffs for partition and separate possession was dismissed. Next paragraph. Dismissed. Next paragraph. The parties shall henceforth be referred to as they were arraigned before the trial court. Initially, the plaintiffs one to 1, 1 to 3. Initially, the plaintiffs 1 to 3 filed was 492 of 2006 against the defendants for partition and separate possession of suit item number 1. Full stop. Later, the defendant number 1 was transposed as fourth plaintiff, defendant number 3 as fifth plaintiff, and defendant number 4 as the sixth plaintiff. Full stop. The plaintiffs claim that they are the children of Mr. Subba Shetty and Srimati Rangamma, Subbanna Shetty and Srimati Rangamma, and that the suit property was an ancestral property and that each one of them were entitled to 1/6 share. Full stop. The plaintiff number 1 claimed that he served the Indian Army between 24/4/1988 and 1/12/1991, and later was serving in the Department of Police. Full stop. He alleged that plaintiffs number 4 to 6 had sold the suit property to the husband of the defendant number 2 during 1989-90 when he was in service. Full stop. He claimed that the said property was sold without his consent and knowledge, and therefore filed a suit for partition and separate possession of his share in the suit property. Full stop. The defendant number 2 filed his written statement contending that the suit properties were not the ancestral properties as it was gifted by his maternal grandfather in the year 1947 when he was a 1-year-old child. Full stop. He claimed that the defendant number 2 was in possession through his parents and that no one was entitled to a share in the suit property. Full stop. He claimed that he sold the suit property in accordance with law, and the other defendants had subscribed their signature to the sale deed as consenting witnesses. Other defendants andre defendant bracket alli defendant number 3, 4, 5. Sorry, 1, 3, 1, 3 and 4. 1, 3 and 4. Full stop. He therefore prayed to dismiss the suit. The defendant number 5 contended that her husband had purchased the suit property in terms of the sale deed dated 6/5/1989, and that after the death of her husband, she had succeeded to the said property and thereafter sold it to the defendant number 3 in terms of a sale deed dated 10/6/2006. So she alleged that the plaintiffs, in collusion with the defendants 1, 3, and 4, had filed the suit to deprive her of the property. So likewise, the defendant number 6 filed a written statement reiterating the contentions urged by the defendant number 5 and claimed that she was in possession of the said property. She also contended that item number 2 of the suit schedule was gifted to her by Ramu Shetty in terms of a gift deed dated 2/6/1947, and that there was no property which matched the description of item number 3, since his father had purchased the same in terms of the sale deed dated 16/12/1981. Based on these rival contentions, the trial court framed the following issues and additional issues. The first plaintiff was examined as PW1, who marked documents as Exhibit P1 to P7. The defendants 1 and 2 were examined as DW. Defendants were examined as DW1 and 2, and they marked documents as Exhibit P1 to D20. Next para. The trial court considered the oral and documentary evidence and held that the plaintiff 1 to 3, 5 and 6 and the defendant number 1 were the children of the plaintiff number 4 and late Subbanna Shetty. Full stop. Subbanna Shetty was the daughter of Bale Rama Shetty and Srimati Timmamma. Full stop. It held that Bale Rama Shetty was the maternal grandfather of the plaintiffs 1 to 3, 5 and 6 and the defendant number 1. Full stop. It held that therefore they were not the family members or co-partners of the family of late Bale Rama Shetty. Full stop. It further noted that the said Bale Rama Shetty had executed a gift deed dated 25/3/1947 in respect of item number 1 of the suit property in favor of the defendant number 1, who was then a minor. Full stop. He, however, created a life interest over the said property in favor of his daughter, namely the plaintiff number 4 and her husband Subbanna Shetty. Full stop. The trial court therefore held that the defendant number 1 was the full and absolute owner of the suit property in terms of the gift deed dated 25/3/1947, and that the mother and that the plaintiff number 4 and Subbanna Shetty were merely guardians of the defendant number 1, who was then a minor aged 1 year. Full stop. The trial court also noticed that the site number 57/2, which was the suit item number 2, was sold in favor of the father of the defendant number 3 in terms of a sale deed dated 16/12/1981. Item number 3 and item number 3. Full stop. Likewise, item number 2 was sold by the father of the defendant number 3. Was sold by the defendant number 1 along with the plaintiffs 4 to 6 in favor of the father of the defendant number 3 on 6/9/1989. Full stop. Therefore, the trial court held that plaintiffs had not made out any case to establish their undivided right, title, and interest in said properties, and hence dismissed the suit. Next, for an appeal preferred by the plaintiffs before the first appellate court also met with the same fate. So, being agreed by the aforesaid judgment and decree, the present appeal is filed. That the learned counsel for the plaintiff submitted that the gifted categorically mentioned that it was not only in favor of the defendant number 1, but also in favor of his mother, mother bracket plaintiff number 4 and his Supanna Shetty, and therefore the plaintiffs were entitled to a share in the said property. To stop. The trial court and the first appellate court have noticed that the gift was absolutely in favor of the defendant number 1, and that life interest was created in favor of plaintiff number 4 and the defendant, and her husband. To stop. If that be so, the plaintiffs do not have any right for the said property and cannot enforce it by way of a suit for partition. To stop. Insofar as the other 2 items are concerned, the plaintiffs are signatories to sale deeds executed in favor of the father of the defendant number 3. And therefore, they had no subsisting right, title, or interest to sue for partition in respect of those properties. The trial court and the first appellate court have appreciated the evidence of the parties in great detail and have recorded a finding of fact that the plaintiffs are not entitled to any share in the suit properties. Even otherwise, the conduct of the plaintiffs and the defendants 1, 3, and 4 in conspiring to file a suit for partition after the land was sold in the year 1989, gives an impression that the plaintiffs have ganged up to cause. Gives an impression that the plaintiffs have ganged up to cause hardship to the purchaser defendants. So, in that view of the matter, there is no merit in this appeal. Hence, it is. Yes. Yes, please. Page 7. Yes. Who are these other defendants? Satyan Reddy, Sunita, you are there. You are Satyan Reddy. Satyan Reddy, no? Yes. You and the which defendant are they? Plaintiff was a party. Then yes. They ended in a compromise in the partition. I thought partition decree. I thought. These are ancestral properties. But the plaintiff can share, notional share kodbekalla. Their partition, she is not a party to it. Then she is a female heir. Even before the amendment, she was entitled to a notional share. Then ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ಲೇರ್ ಅಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಆಯ್ತಾ ಇಲ್ಲ ಆಯ್ತು ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ಯಾ ಕೋರ್ಟ್ ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ ಆಗ್ಬೇಕಲ್ವಾ ಎಸ್ ಆಯ್ತು ಪಾರ್ಟಿಷನ್ ಆಗ್ಲಿ ಬಟ್ ಶಿ ಇಸ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ನೋಷನಲ್ ಶೇರ್ earlier partition, even before 2005 Act, she is entitled for a notional share. Then, suit is entitled decree to which she is not a party. Howdo? Yes, the decree as a co-personer. Plaintiff is held entitled for 124 share anತಾರೆ ಮತ್ತೆ she is not entitled to 1/8 notional partition ಕೊಟ್ಟಿರೋದು ಮತ್ತೆ what is wrong right please support your content yes correct as per 2005 amendment ಕೊಟ್ಟಿಲ್ಲ share ಕೊಟ್ಟಿರೋದು notional share notional share she is entitled 2005 ಪ್ರಕಾರ ಕೊಟ್ರೆ she is entitled to how much 1 2 3 4 5 6 7 1/7 ಕೊಡಬೇಕಾಗಿತ್ತು 1/24 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ತಂದೆಗೆ ಒಂದು ಶೇರ್ ಇಟ್ಟು ತಂದೆಗೆ 1/8 ಅಲ್ಲಿ ಡಿವೈಡ್ ಮಾಡಿದ್ದಾರೆ So what is wrong? Share ಬಗ್ಗೆ discussion ಮಾಡಿದ್ದಾರೆ Please come to para 20. Careful. Careful. This regular second appeal is filed by the defendant number 1, 2, 3, OS number 78 of 2008. Only defendant number 1. This regular second appeal is filed by the defendant number 1, challenging the defendant number 1 in OS number 78 of 2008, challenging the judgment and decree dated 12/7/2010, passed by the trial court and confirmed by the first appellate court in RA 117 of 2010, by which both the courts held that the plaintiff was entitled to undivided 1/24th share in the social properties. Next, the parties shall henceforth be referred to as they were arraigned before the trial court. The appellant herein was the defendant number 1, while the respondent number 1 was the plaintiff, and the other respondents were the defendants in the other defendants in the suit. Next paragraph. The suit in OS number 78 of 2008 was filed for partition separate possession of the suit properties which were claimed to be joint family ancestral properties, which were originally owned and possessed by the father of the plaintiff and defendants 1 to 3 and 5. Full stop. It was claimed that the said properties were acquired by the father of the plaintiff at a partition between him and his brothers. Him and his brother. On 23/9/1950. Full stop. The plaintiff claimed that the defendants were acting detrimental to her interest and denied her share in the suit property and therefore filed the present suit. Therefore filed the suit for partition. Next paragraph. The defendants 1 to 3, 5 to 9 contested the suit. Stop. They admitted that the suit properties originally belonged to their father, Nagappa. They, however, contended that a suit in OS number 123 of 1998 was filed for partition and separate possession by the defendant number 1 to 3, and that the said suit resulted in a compromise, ended in a compromise on 11/4/2001. Stop. Therefore, they claim that the plaintiff cannot claim a share in the suit property as a co-partner, since such a right arose only after the Amendment Act of 2005, which was, however, subject to the condition that this property should not be subject to any partition or alienation before 20th of December 2004. Stop. They also contended that certain other parties were not added in the suit, and therefore the suit was not maintainable for non-joint of necessary parties. So based on the above, the court framed the following issues. The plaintiff was examined as PW1 and she marked documents as Exhibit P1 to P10. The defendant number 1 was examined as DW1 and he marked documents as Exhibit D1 to D9. To stop. The trial court, after considering the oral and documentary evidence, held that the decree passed in OS number 123 of 1998 had not attained finality. To stop. Even otherwise, it held that the plaintiff, as the female heir, was entitled to a notional share in the share that may be allotted to the father. Full stop. The trial court therefore held that the defendants 1 to 3 and their father were entitled to 1/4 share in the social properties and allotted 1/24th share to the plaintiff and the other defendants, including the other daughters, other sisters of the plaintiff. Full stop. being agreed by the aforesaid judgment and decree, the defendant 117 of 2010 to stop. The first appellate court considered the claim of the plaintiffs and the plaintiff and defendants, and in view of the settled position of law, held that the plaintiff was entitled to a notional share out of the share of her father, which was aptly done by the trial court, and hence dismissed the appeal. Next, being agreed with the aforesaid judgment and decree, only the defendant number 1 has filed this regular second appeal. Next, the learned counsel for the plaintiff submitted that, defendant number 1 submitted that since the suit properties were already subject to a partition in OS number 123 of 1998, in view of the proviso to section 6 of the Hindu Succession Amendment Act 2005, a suit for partition was not maintained. Stop. Next para. It is not in dispute that the plaintiff herein was not a party to OS number 123 of 1988. She was a party or not? She was not a party. So also, it's also not in dispute that the suit properties were ancestral properties. To stop. The relationship between the parties is also not in dispute. To stop. If that be so, the plaintiff as a female heir, along with her sisters, were entitled to an undivided share in the undivided notional share in the share of their father, namely Nagappa. To stop. The trial court and the first appellate court have rightly applied the position of law and appreciated the evidence on record, and have held that the plaintiff is entitled to a notional an undivided 124 share in the social properties. The finding recorded is in line with the law laid down by the apex court in the case of Vinita Sharma so. In view of the matter, there is no merit in this appeal and the same is dismissed. Vinita Sharma Baral, Vinita Sharma, law laid down by the apex court in the case of ಯಾವ್ದು ಇದು ನೋಷನಲ್ ಶೇರ್ ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅದು ಹೇಳ್ತೀನಿ ಅದನ್ನು. Yes, please. Plaintiff second appeal. On what count?
Lord, the property inherited by father from these parents.
Appeal was filed by whom?
By me and also the purchaser. Two appeals were filed.
There are two appeals.
I have filed the appeal on the ground that the purchaser has to be a one of my purchaser purchased property from his father. And the trial court has held that the third person was right and the subsequent father has got the property.
A bona fide purchaser Hindu law
principles that the legalistic portion of the issue that issue has not been taken.
Yes.
The perfect what my lord holding that property left behind by grandfather with the father. Father is survival
the finding is
your lord is finding the finding I not answer.
Yes. Yes. Where are reading? Where are reading? Page 35. Page 35. Therefore, the contention.
Therefore, the contention is number 3. The writing has the two property property has considered the spread upon. Subsequent page next you last kindly come to page number reading it.
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ಸರ್? ಪೇಜ್ 36.
On the fifth line, in the present case, there is no dispute that the plaintiff and defendant number 2 are seated as defendant number 1 and the latest of the but issue not in the present case is not made in the outcome of case. The question as to the has become the accused property or the hands of defendant number 1 and 3. The referring to 1986 for that very any property already share of the son. Events are not there, it becomes accused property. Those judgments are being referred.
Yes.
There are last line in the judgment reference. Last line. That related property as an last line. Next line is undivided and not as part of the family. Hence, it could not be clear because they are included in the computing assessment. These judgments are referred not also. A person acquired a property, the partition is the full property, the children are, the sons are not there. Not the judgment.
Yes.
Our judgment referred not.
What is the law? This is a judgment. It's a single.
Any property held by the father from
Justice Nariman or Vinta Singh.
1995.
Which is a judgment single, enter single. Issue. One other referment will be included.
1995 Karnataka page 25 is the property held by the father from property the property, not the property.
Yes.
1985 Karnataka. 1924 the privy council.
You appear.
That is prior to that. If the claim is the same, the claim is across the court, what the meaning of the non-company problem? There is absolutely no way to report at all. Yes. It comes to the father who and we have not divided the property.
So how did you get this property? How did you get this property?
I got it at other sale.
Sold it.
Sale it from defendant number 1.
You are the purchaser. Yes.
And the father earlier in 1969 has executed a sale in favor of Noria. And subsequently in 1974, we repurchased the property from Noria. Exhibit P26. Those sales are not challenged. For example, they got the those sales are not subsequently when it was to me that is challenged. If the earlier sale is not challenged, and he repurchased the property, it
must come back to the family. Why should they challenge?
Not come back to the individual name is purchased the property.
Yes.
The individual name is purchased the property and subsequently is voted to me. 1995. Subsequently, the suit for partition has been filed.
Well, which property is purchased by you? Schedule A.
And second aspect of the matter, what the client was observed that they declared the share of 155 with 20%. That share can be given to the property. To work out the equity is different number.
How can they?
That observation, in view of that, they have filed nothing. They filed nothing in the process. I being agreed with other people, they are also filed nothing. My understanding, in fact, their appeal, which is we discussed, doesn't seem to be challenged. So that aspect of the matter is there. And as far as my appeal, 44 is part of it. Second aspect of the matter is, at least evidence is clear that there are other properties which are landmark properties in survey number 64. Survey number 39 is there. My grandfather paid only 1800. Those properties are not included. In fact, the two which is depending on partial market, the proper observation of the suit are not maintainable. The suit for partial market. The only target made for defeat of buyer. The target is to
Admit the substantial questions of law which arise for consideration in the appeal is whether number one, whether the trial court was justified in directing allotment of the facial property to the share of the defendant number one, which was sold to the defendant number 3 and 4, 3 and 4. Instead of directing the parties to work out their remedy in final decree proceedings. Number 2, whether the first appellate court committed an error in construing that suit item number, that facial property was owned and possessed by the defendant number one as his individual property, notwithstanding the fact that when the defendant number one succeeded to the said property, the plaintiffs were already born. Huh? No, when did this person die? When did the defendant number one die? Pendency of the suit. How old were these plaintiffs?
I think in 2001 he made the evidence.
Anyway, that's a question of fact. That you can argue that there is no evidence, no pleading. Which is the judgment of Justice Nariman Singh. Famous judgment, the father does not take it absolutely after the birth of the children, which is one court officer Barkalade.
Property belongs to his grandfather. Correct. Now the joint property, I completely go down to understand that it will not automatically. The moment the change is considered, it is right in the property.
But even if it belongs, even if it belongs to the grandfather, even if it belongs to the grandfather, if the property is disposed of before the children are born, then you cannot seek for a claim. The children cannot seek for a claim. Yes, yes. Another question I could, whether the deceased defendant number one succeeded to the Asian property as a class 1 heir of his father, and therefore took it as a self-acquisition. To stop. If yes, whether the plaintiffs could claim for a share in the said property during the lifetime of the defendant. Uttam Singh, Uttam Singh was Sobhag Singh. No idea, Uttam Singh judgment, no idea. I think he must know it. Uttam Singh created a lot of confusion in the courts. Yeah, even otherwise, how can the trial court say that? It's all right. It's all right. Order 41. Order 42 applies even to second appeals. If order 42 applies, then order 41 rule 33 also applies. I think
double court.
Workhold. Since the appeal is admitted, comma, the respondents are directed. I think what in the operates from today. Since the appeal is admitted, comma, the different respondent shall not alienate. The
Respond number 4 and 5.
4 and 5 shall not alienate the Asian property during pendency of this appeal. Likewise, comma, sorry. Yes. Next. ಅದೊಂದು ಸ್ವಲ್ಪ ನೋಡಿ ಅದು ಉತ್ತಮ್ ಸಿಂಗ್ ನೋಡಿ, maybe it might help. ದಯವಿಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಡ್ಜಮೆಂಟ್ ಮಾತ್ರ ಕೇಳಬೇಕು. ಈಗಾಗಲೇ 3ನೇ ಸತಿ ಬರ್ತಾ ಇರೋದು. ಯಾವುದು? ಅಲ್ಲಲ್ಲ ಯಾವುದು? You said 31.
1047 and 1049.
Correct.
I filed an application because my colleague.
ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಈಗ ಅದನ್ನು ಮಾಡ್ತೀನಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. If there is a merit, I will restore it. Otherwise, no restoration. Merit ಇದ್ರೆ ಹೇಳಿ. It's all right, madam. Yes.
I did applied here. 2 cases.
ಇಲ್ಲಿ ಬಿಡಿ ಯಾಕೆ ಬಂದ್ರು 11 ನಡೀತಾ
These two appeals arise out of the same suit? Three different suits. 1047 is in which suit? Suit number?
1047 is arising out of OS number 392/2003.
391. 391 ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ. 1047. 392. 1048.
1048 arising out of OS number 391/2003. 1049 arising out of OS number 507/2003. Is the OS number 391 and 392.
ಪ್ರತಿಶ ಬಂದ್ರೆ ಇದು ಆರ್ಬಿಟ್ರೇಷನ್ ಶೈಲಿ ಆರೇಜ್ ಹಾಕೊಳ್ಳಕ್ಕೆ
One is Kitwe Swami and S. Swami. There are 2 sides.
OS number 392.
OS number 391 and 392.
391 ಯಾರು ಮಾಡಿರೋದು?
391.
OS number 391 ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು?
S. Swami against the defendant. Defendant is same.
Defendant is the same in all the suits.
In all the suits.
Yes, one. So 507 ಯಾರು ಮಾಡಿರೋದು?
507 Lakshmana filed the suit against us.
Same defendants.
Same defendant.
Yes.
But the facts of the case is that the right case was observed one of the scheduled property, site number 24B.
ಯಾವ್ದ್ರಲ್ಲಿ?
In error case 391 and 392 site number 24B and 25B. It was arising out of survey number 6 Sonenari village belong to the government of Karnataka. The government of Karnataka has found the sites and allotted siteless people.
Yes.
Issued Hakku Patra. So this is his property situated in survey number 6.
Yes.
Hakku Patra issued by the government in the year 2082. Since from the issuance of Hakku Patra from 1982 up to 2003, I was possession of the property, and in 2003 I obtained the plan and about to construct the building. So defendants interfering. Therefore, I approached the police station and it was before we applied the soon for declaration. That the defendant attention that my property is serial survey number 139 in 507 ಅಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ this is my 507 this property belongs to the I kindly see that is entirely different, that is 39 and of interest is claimed, whereas my property is only 50-30 sites. Hakku Patra issued by the government.
Your property, there is so many defendants. Who are you?
I am the plaintiff for defense only and there is only.
You are for the plaintiff.
And the plaintiff.
Declaration suit ಕೊಟ್ಟಿಲ್ಲ ಅಂತ appeal ಹಾಕಿದಿರಿ.
Yes.
Your suit for declaration is dismissed.
Yes.
Injunction is granted. Yes.
So suit filed by me because of their interfering in this property, site number 35B, 34B, it is belong to my this property.
Why is the declaration suit dismissed? Relief of declaration, why is it dismissed?
That is my question. This is survey number 136 and I have not produced the survey number 6 before the trial court. Only Hakku Patra was issued and government has issued and government is accepted by the exhibit P1 and it is Hakku Patra issued to the government. Whereas it is defendant has taken the advantages of the weakness of the plaintiff. The defendant that filed a suit, my property is in survey number 139. I have a property, purchased a property 39 and of Bundas. That is entire property in OS number 507. He is claiming that is entire property, survey number 136, survey number 136, measuring 39 Gutta, situated at Ulla village, Yeshwanthpura Bhopli, Bangalore, North Alabama. This is adjacent property, no way connected to my scheduled property is concerned. Mine is only site.
Month.
But I told in the appellate court that it's not properly appreciated the case, and only because of this suit is dismissed against me because I have not produced the survey number 6. Survey number 6 is not at all existence. Later, at the appellate stage, I have filed the survey number 6. It was clearly established that it is government land.
So you are arguing for admission, so therefore you should make out a point. You are arguing, not arguing for final hearing.
So therefore, the plaintiff private declaration proof, it was dismissed on the ground that they are not established because
Not a suit for declaration, suit for injunction. ಯಾವುದು?
Site number 24B and 20.
OS 390. OS 391.
OS 391 and 390.
391 is for injunction, sir.
Yeah, I don't know. You tried there. permanent invention. Declaration and invention, all cases.
Yes. 392 is in respect of which site number? 392 is in respect of which site number?
392, this is a site number, not 24B.
392 is 24B.
Yes.
507?
507 is 39 guntas. Entire property situated in 136. Adjacent land. That is entire land, she protect the suit. But that suit is cannot be, he is only taking advantage of this situation.
This is suit and counter suit.
Yes. Our suit is entirely different aspect.
Ninja.
And the size of the land, 39 guntas, entire land. In survey number 136.
Schedule Act, Pickering Act ಇಲ್ಲ ನೀವು. Pickering OS number 507 ಇಲ್ಲಿ.
507 ನಲ್ಲಿ ಇಲ್ಲಿ ಹಾಕಿದೆ.
136.
Schedule Pickering ನಲ್ಲಿ ಇದೆ.
South by land in survey number 6 ಅಂತ ಇದೆಯಲ್ಲ.
Survey number 6 is mine. 391, 392. We have filed a suit for declaration and injunction in respect of site number 24B and 25B, situated at survey number 6.
Yes.
Issued by the government of Karnataka.
Yes.
Based on the Hakkupatra.
Yes, please.
In the year 1982. This is my case, 2 cases. Because of that, defendant has.
Yes, madam. What is your right in respect of survey? What is your right in respect of survey number 6? Yes. Yes, Mr. Where is the finding? Page number 21 of the trial court judgment.
That in RA 75, document NDC page para 28. RA 75 by 2011. Page 28. Read only is admitted that in the class examination made by the trial court. Swaneerve gram survey number 6. ಮತ್ತು ಉಲ್ಲಾಳ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 136 ಯಾವುದೇ ಸಂಬಂಧ ಇರುವುದಿಲ್ಲ. ಅದು ಎಂಟನೇ ಡಿಫರೆಂಟ್ ನಂದೆ ಬೇರೆ ಅವರೇ ಬೇರೆ ಅವರು
ನನಗೆ ಅರ್ಥ ಆಯ್ತು ನಾನು ಕೇಳ್ತಿರೋದು why was you sir ನಾನು ಕೇಳೋವರೆಗೂ will you please listen to what is running in my mind. Why did the trial court and the first appellate court dismiss your suit for declaration? ಅದನ್ನ ಹೇಳಿ. Don't argue for fine hearing, mister. RA 77. Page 13. Page 13. What? ಹೇಳಿ ಓದ್.
Let's see, 14 is there. RA 77, 2011.
What?
Specifically argued by the Union Council for the Respondent Right that these are good owner in position of good property. One environmental was argued owner of the survey number 136. Measuring 5 acres registered. After his death, the said property has been divided among his 6 sons under Panchayat Monica to to an extent of 39 plus each. The plaintiff has purchased the suit property and registered sale deed from one Karnataka. The defendants have no minor rights, right interest over the defendants of the suit property. Because I am not.
So please read. Don't argue for fine. It is for admission, Mr.
The plaintiff has produced all the documents to prove her case. The trial court is properly appreciated over the documentary evidence produced by the plaintiff. The slide number 24B and 25B are not in existence as part. There is no records produced by the appellant defendants to prove the existence of their property in land survey number 6 of Swaminani village. The plaintiff has proved her case by producing more than documentary evidence in respect of her suit property. The judgment of the trial court is proper and correct. But in this case, my submissions in that. This case, he claimed my property.
I'm repeating it again and again, sir. Please don't argue for fine. Please make out a case for admission, Mr.
The plaintiff has proved her case by producing more than documentary evidence in respect of the suit property. The judgment of the trial court is proper and correct. It is great that this appeal is dismissed as the word of money. There is a delayed filing appeal. So easy. Para 18, are carefully gone through the contents of IA number 2 and list of documents produced along with this application. The appellant has not shown sufficient.
Please come to page number para 36.
The defendants have produced the proof of office of the Hakupatra issued by the government. Original Hakupatra are produced in suit number 391/2003 and 392 of 2003. There is a overwriting in respect of the EO issuance of the said deed. The boundaries mentioned in the slide here of Eriswamy number 25B as per Hakupatra and exhibit D7 are not tallied with the boundaries mentioned in encumbrance certificate of state site as per D8 to exhibit D10. If really Hakupatra was issued after 28th annual Independence Day function, he ought to have issued in the year 1975, 1947 plus 28. But the defendant have pleaded in the request statement that government has issued Hakupatra to their sites in the year 1982. The defendants have not got examined any of the officials concerned to prove the overriding and existence of the sites at spot. The names of the defendants are not entered in respect of the sites number 143 Panchayat records or revenue records. There are no such documents produced by the defendants except people to be are not pertaining to the social properties. The Tahsildar has issued endorsement that service case plan and other records are not available in the office file of this said Tahsildar, Mangalore, South Talo, as per the endorsement. If the defendants have failed to produce their important and material documents, their case not accepted by this. At 7 or 41 to 27, we have produced late.
Produce ಮಾಡಿದ್ರು.
It is not available in the record because in pertaining the 82 now 2003 they are into care.
Sir, ನೀವು ಹಕ್ಕುಪತ್ರ ತಗೊಂಡು ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಏನು?
Easy actually, RTC expect all the 11 documents that are pertaining to survey number 6. All the survey number 6.
Forget the defendant. You do not prove your title. ಹಕ್ಕುಪತ್ರ ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ? ಯಾರನ್ನ ತರಿಸಿ ಹೇಳ್ಬೇಕು?
It was not denied by the.
You should stand on your foot, isn't it? Should you not establish the Hakkupatra?
And this question of law is that they are claiming it is not you who is the owner of that. Taking advantages the situation that he is claiming.
Forget her. Indeed.
in survey number 6, all the documents you have produced. And in
What
survey
is there
number
to
6,
show that it was granted to you?
BDO is the government of India, is government of Karnataka has issued Haku Patra. That is
In a suit for declaration, should it not show the valid flow of title?
Not, you are not brought the witness from the government.
That's like Allah.
It is issued by the government and Patra was issued and.
ಅದು ನೀವು ಹೇಳ್ತಿರೋದು ಗೌರ್ಮೆಂಟ್ ಅವರು ಹೇಳ್ತಿದ್ದಾರಾ?
Government never said anything about its existence. Survey number 6 was.
Suppose if I file a suit against you, against a non-existent property, you say that I am not interested in the suit. Should the suit court decree the suit automatically? Should it not prove?
It was not existence and the end of it was existence.
So the court has doubted the Hakku Patra.
On the ground that because she is claiming under
Not on that.
this property.
Not on that
No.
note.
It is not existing. 39 because survey number 136.
Is other than the Hakku Patra, what you have?
Other than Haku Patra, we have produced all the 11 documents.
Yeah.
Easy endorsement, tax paid receipt, final notification.
Where is the P5 layout plan?
Layout plan.
ಇಲ್ಲಿಂದ ತಂದಿದ್ದು.
Exhibit P8 should be previously.
Exhibit P8 is a letter issued by LIO. ಅದು ಅವ್ರ ಸರ್ವೆ ನಂಬರ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. ನಿಮ್ದು ಹೇಳಿ. ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಅವ್ರ ಸಂಬಂಧಿದ್ದು. ಅವಾರ್ಡ್ ಅವ್ರ ಸಂಬಂಧಿದ್ದು. Letter issued by LIO.
Only in respect of this, survey number 6 only
ಅಷ್ಟು ಸಾಕಾಗುತ್ತಾ ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ಗೆ?
And deeper they have issued because not available the existence of survey number 6. The government.
ಮತ್ತೆ ನಿಮ್ ಕಾಲ್ನ ನೀವೇ ಕತ್ತರಿಸ್ಕೊಂಡಿದ್ದೀರಾ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಇಲ್ಲ ಅಂತಾರೆ.
ಮತ್ತೆ?
But later at the time of filing the because the appellate court at 47 rule 1 they have produced the sketch also, but it was not it was rejected. And 41 is the
Office is directed to secure the trial court record. You see the record ಒಳಗೆ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದ್ರೆ
ಈಗ ಹಾಕಿದೀವಿ ನಾವು R6 survey number 6.
ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಗಿರೋದಕ್ಕೆ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ then we'll consider. Otherwise, why should it be considered?
ಹಾಕಿದೀವಿ ಆಮೇಲೆ RTC ಎಷ್ಟಾಗಿ ಸರ್ಕಾರ
Office directed to secure the TCR list of trial court records are this.
Kindly whatever is the area.
At the request of the London Council for the appellant, the order dated 25/10/2021 is recalled. Now, IA 1 of 2022 is filed for recalling the order dated 25/10/2021. To stop. In view of the statements made in the affidavit accompanying IA 1 of 2022, the order dated 25/10/2021 is recalled. The counsel for the appellant is directed to comply the office objections within a period of 1 week from today. In the meanwhile, office is directed to secure the trial court records and list this appeal for admission after trial court records are secured. So, MR Rajkumar.
My lord, 32, my lord, I am appearing for appellant. It's a suit, it's second defendant's second appeal. It's a divergent finding, my lord. Trial court dismissed the suit. The defendants, plaintiffs have filed a regular appeal. Judgment of the trial court is reversed and suit came to be decreed. A question is now pending before the larger bench before the apex court, arising out of the judgment rendered by our High Court in Revan Siddhapa's case. The same question is also involved in the present matter. It's a controversy between the two.
Therefore, Revan Siddhapa case cover ಆಗುತ್ತೆ.
2011 Supreme Court nolage Supreme
Hey,
Court
sir.
nolage
That is a question which is in consideration.
2011 SCC page 1 nolage it was referred to the larger bill. Revanche Siddhappa and another versus Mallikarjuna.
Call for records. The substantial question of law which arises for consideration in this appeal is whether the plaintiffs being the illegitimate children,
Defendants.
The defendants before the defendants being the illegitimate children, the defendants being the second wife and children of the propositors.
Srinivas Murthy.
They say that the first wife was deserted.
Sir,
There is no
plaintiff was the
Plaintiff claims to be the first wife.
first wife.
There are two issues are raised.
Yes. Yes.
Defendant number 1 is second wife and the others are illegitimate children.
Shoot and
Suit was dismissed on the ground that during the lifetime of Srinivas Murthy, when there's a desertion of the first wife, a suit was filed by the wife against Srinivas Murthy on declaration. That was ended with compromise. Certain properties are given to the first wife as a full and final settlement. It's an end of the matter. Thereafter, the present suit.
Whether the defendant number 1 being the second wife and defendants 2 and 3 being the alleged illegitimate children of Srinivas Murthy were entitled to an undivided share as co-partners in the suit properties, which were admittedly ancestral properties. Ancestral properties.
Adityan, there is no finding. Yes, the property acquired by Srinivas Murthy in Tale. Anyhow, that area is also in
Which were stated to be, which were claimed to be ancestral properties. This paper books to be filed within 8 weeks.
It's not for stay of the judgment.
Of a final decree shall remain state during the pendency of this appeal. What is this? How many times should be listed? ಇದಲ್ವಾ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಬರ್ತಿತ್ತಲ್ಲ ಅದ್ 3 ಸತಿ ಬರ್ತಾ ಇದೆ, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ. ಯಾವ್ದೋ ನೆನ್ನೆ ಬಂದಿತ್ತಲ್ವಾ, ಯಾಕೆ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ? ಅಲ್ರಿ 3 ಸತಿ ಕಾಲ್ ಮಾಡಿದ್ರು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಹೆಂಗ್ರಿ? ಪ್ಲೀಸ್ ಕಮೆಂಟ್ ಅಂತ. Number? No, sorry, Mr. Memo ಕೊಟ್ಟೆ ಹಾಕ್ಸಿರೋದು ಇದೆಲ್ಲ. 25 mediation report ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ವಾ? ನಾಳೆ ಮರ್ತು ಬಂದ್ರೆ you are appearing in this appeal instead of in the place of Sachin. ಏನ್ ಟುಮಾರೋ ಅಂದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಈಗ ಏನು? ಪ್ಲೀಸ್ ತರಿಸಿ, ಇವಾಗ ಏನು ಹತ್ರದಲ್ಲೇ ತಾನೆ ಆಫೀಸ್ ಇರುತ್ತೆ.
Court officer. Court officer.
Sir.
Sir, serial number 46 ಏನಾರ ಅಡ್ಜರ್ಮೆಂಟ್ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ ಸರ್.
ಫೈನಲ್ ಹಿಯರಿಂಗು?
ಸರ್ ಅಡ್ಜರ್ನ್ ಆಗಿಲ್ಲ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಅರ್ಜನ್ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
52 ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
52 ಇಲ್ಲ ಸರ್.
ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ.
ರೀಚ್ ಆಗ್ಬೋದಾ ಸರ್?
ಹಾ ಸರ್.
ಆಗಲ್ಲ.
ಆಗಿದೆ.
ಇದ್ಬಿಡಿ.
ಅದೇ ಗುದ್ದಾಡಿ ಬಂತು ಬೆಂಗಳೂರು ಬಂದದ Yes, Mullers, I have filed an application for relaxation of condition that were imposed on 37/2020. That what I have constructed a function hall, and it was unauthorizedly constructed earlier. Now, my lord, I have got converted the land from agriculture to non-agriculture. But the practical problem is that, my lord, page 33, my lords may kindly produce.
Page 33.
33, my lord. The building constructed is a blue color shed, my lord. Now, my lord, the half the portion which is parking, this is Google Map, my lord, I have produced.
The page?
My lord, page 33.
33 something else.
My lord, Google Map, my lord, I have produced. Google Map. In that application, my lord, which I have filed on 25/1/2022. In that, my lord, a Google Map has been produced.
Yes.
Lord, now I have got non-agriculture to agriculture, non-agriculture order.
Yes, please.
Yes, I have got converted my land by compounding fees and penalty by depositing 28 lakh rupees. Now the practical problem is that your lordship had imposed the condition that till the post facto permission is granted, the function hall should not be open. Now the practical problem is that my lords may see a Google Map. In that, my lord, my function hall is backside, but as per CDP plan, my lord, the front side parking area, that is only a commercial. Now the backside is residential area, and now, my lord, the Gulbarga Development Authority already have proposed it is abiding to the ring road, and already proposed that, my lord, it will also be commercial, but it will take much more time, my lords. There is no meeting, and I already filed application for change of plan also. But now the question is that, my lord, since
What is it you want? What is it you want?
the only my request is to my lordship is to relax the condition which have been imposed on 37/2022 your lordship's order. That,
Yes.
my lord, till the all the sanctions have been extract for permission and construction permission, I will not be open for public purpose. I have already complied with lordship order partially, my lord. Conversion order I have obtained, my lord, page 18.
No, but what are the conditions imposed?
Well, my lords may see the internal page.
The conversion aita.
Yes,
Conversion aita.
conversion is all page 18.
What does the master plan say?
Lord, that's what, Lord, I had showed the Google map. The front portion, which is parking area, Lord, it is only for commercial as of now. But there is a proposal which has yet to be come in a meeting, Lord. The entire building will also be come in a commercial, which is proposed by the Kalburgi.
But this is converted for what purpose?
Lord, it is converted for commercial purpose, but they are not considering, since it is not in accordance with the CDP. The Deputy Commissioner has converted to NA as a commercial purpose itself, but the urban development authorities are not considering it. But I am helpless, Lord. I am unable to open my building since 2 years. Though there is a commercial order of any order, Lord.
Yes, for yes. Gulbarga Development Authority.
Government advocate is appearing.
Yes, yes, government advocate.
My lord, I am not hearing, my lord. I am not hearing. I am not getting anything, my lord. Submission made.
claim ಇದೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ
Ravishankar, please mute your mic, mister.
ಬೇರೆಯವ್ರನ್ನ ಕರೆಸ್ಬಿಟ್ಟಿರೋ ನೋಡಿ.
Yes.
My lord, I am not hearing. I am not getting, my lord.
So what he is saying is,
my lord, the condition
as per your lordship direction, my lord, the condition was imposed. Until the aforesaid exercise is completed, the petitioner shall not undertake any construction or completion of the building and shall not throw open the building for any public gathering. But my lord, here, this was the order, my lord, your lordship passed it, my lord, and the commercial purpose is only 165 feet. 50 meter matra commercial road in the the actual building is beyond that area, my lord, that 165 feet.
Yes. Yes, Mr. Deepak Bharat.
Lord, sir, now what my request is that, my lord, I have paid compounding charge of 28.
I am not hearing, my lord. I am not getting it.
My lord, is getting me.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
Lord, sir.
No, I can hear Mr. Bharat. How is that you are not able to hear? Sukumar Tengli avare.
Please, my lord.
Can you hear Mr. Deepak Bharat? Why don't you speak out, Mr. Bharat?
ಬಹಳ ಇದರಿಂದ ಕೇಳಿಸ್ತಾ ಇದೆ, ದೂರದಿಂದ ಒಟ್ಟು ನಮ್ಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ.
My lord, now my only request is that
now the change of land is required, my lord. Here only the commercial purpose is reserved abutting to the service road. From the end of the service road point from 165 feet matra commercial anta ide, and beyond the building is situated behind 165 feet. Therefore the land, the use of land has to be changed.
What Mr. Bharat is saying is that it is already converted for commercial purpose.
Yes.
So the land use must be for commercial use.
My lord, the conversion order is for commercial purpose.
So therefore, unless it is demarcated in the master plan for commercial purpose, how can it be converted for commercial purpose? Commercial purpose anta irbekalva.
Yes.
ಹೌದು, ಕಮರ್ಷಿಯಲ್ ಪರ್ಪಸ್ ಅಂತ ಏನೇ ಆಗಿದೆ, ಆದ್ರೆ ಅಲ್ಲಿ ರೋಡ್ ಇಂದ 50 ಮೀಟರ್ ವರೆಗೆ ಕಮರ್ಷಿಯಲ್ ಯೂಸ್ ಅಂತ CDP ಪ್ಲಾನ್ ಅಲ್ಲಿ ಇದೆ. Beyond that residential use anta ide. Therefore this petitioner has to seek for the use of the change of the land use.
The front portion is to seek for
the urban development authority in Gulbarga is not permitted to beyond 165. He has to approach the government.
Yes,
for change of land use.
I am not denying that. No, I am ready to approach the government. I am ready to pay the fees, appropriate fees and conditions. The only request, my lords, before this court, since 2 years the building is in law. I have already.
What can be done, Mr.? You can't put up construction without complying the norms.
There might be irregularities, but there is no illegality, my lord.
We do not know. It looks illegal because you know setback.
No, it has setback is left, my lord. Everything is left, my lord.
Shall we appoint a commissioner to find out whether setbacks are left?
Yes, my lord. Yes.
Padla?
Yes.
Will you take the risk of them?
Yes, my lord. Yes. Setback is left. Parking, my lord. See the Google map, my lord. I have left to show since from road.
Yes, where is the plan then? Where is the plan?
My lord, since the endorsement has been issued by the corporation, my lord, I have to obtain single layout approved plan from the Urban Development Authority.
Without a plan, you put up construction. After putting construction, you say you give me permission.
My lord, my only my request is
please get it converted. Change of land use marshal.
Already I have filed application for change of land use. My lords may see at page on 28/3/2022. I have already filed application for change of land use and
pursue it.
My lord, my only request is that, my lord, it will take much more time.
We cannot. No, sorry.
My lords, the only
want to set a bad precedent, Mr. Bharat. The law requires you to get change of land use. Can we permit you to open the Kalyan Mandapa without getting change of land?
My lord, I am 100%.
Short circuiting. Sorry. An application is filed for relaxation of the condition imposed by this court.
My lords, may I permit to withdraw the application?
Current Council seeks permission to withdraw IA 1 of 2022. Hence, IA 1 of 2022 is rejected. Yes. ಅದೆಲ್ಲ ಅದೇ ತರ ಬರ್ತಾರೆ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ನಮ್ಗೆ
The only question is it not be precedent. Let that observation, Lord, because 2.5 years over.
How can the High Court discriminate between same similarly situated people by saying that we should
Lord, see the Google map, Lord. All the surrounding areas are densely populated, no conversion, nothing, Lord. I am ready to abate the condition, Lord. Let there may be some relaxation, Lord. I am ready to give the bank guarantee also.
Relaxation, you get it done at the government level. The High Court cannot be a party to it.
Lords have imposed the condition, Lord. Lords, I
How can
cannot
we relax the condition, Mr. Condition of requiring you to obtain change of land use? How can the High Court relax in what provision of law?
Lords have imposed the condition that, Lord, unless that exercise has been done, it should not open. Now, my rights have been curtailed, Lord. Since a huge investment borrowing has been done by relatives, my Lord, I am paying interest on that.
You have withdrawn it.
My lords may exercise the discretion, my Lord. That's the
Sorry. It will set a bad precedent, Mr. Deepak. I would have it will send a Gulbargal modle kanun illa. Nobody follows the law. And High Court wouldn't want to add to the confusion. I was also in Gulbarga for 2 months.
No, what my lords have directed, I have paid the compounding charges and penalty also, my lord. Now my only fear is that, my lord, time lapse. Another 1 year goes, my lord.
There's a risk that you have taken. Can't help it.
That's the only.
My admission. Hirematad. Yes, please.
Was a partition in year 1982. Based on that, proof of their accessibility evidence, they are not the evidence denied their relationship. They produced the genealogy tree and that has been accepted by the evidence. The genealogy produced by the evidence is given. The evidence produced exhibit B9, which is the basis of their claim.
Yes.
The partition taken place between the dependent number 1 and their father, which has been not proved by the plaintiffs. For the proof of the exhibit, they have examined the right of the document who has not recognized the signature. In the first instance, the High Court dismissed the suit on thereafter, on the appeal, the High Court has declared the suit.
Yes.
The appellate court is of the opinion that the defendants ought to have.
No, but how have you proved the partition? How did you prove the partition dated 20th of June 2007? How have you proved the partition deed dated 20th of June 2007?
My title, my father's title was to the exhibit B2, B3, my lord.
Yes.
Only my father's name has been entered in the name of, entered in the column of the column number 9 as Pattaga. The plaintiffs claim that therefore father and his father was the entitled for the property, my lord. Based on that, my lord, they claim that they are they are having half share in the succession property, my lord.
Yes.
But my evidence claim is that the property belongs to the father of the defendant. Only name of the father has been entered.
Yes.
Food for the declaration of title of the great
Yes.
but great grandchildren of one man. But property appears to have been purchased by Mullah Rajappa for a registered date dated 11/6/1971. Thereafter, Mullah plaintiff claims that there was a partition between the children of Mullah Rajappa and the property has fallen to the share of the plaintiff's father.
Yes.
But the plaintiff claims that when he went to verify the khata, he found that the name of the first defendant had been entered in the khata, and the first defendant had executed the sale deed in favor of the second. Therefore, my lord, he has filed issue for declaration and denial.
How is the defendant amount related?
Defendant number one, my lord, she is the daughter-in-law of the vendor of the plaintiff's father, grandfather.
Daughter-in-law of the vendor of the
the grandfather of the
What is that?
even after the execution of the sale deed, the defendant is claiming right is the case that is made out of me. She has executed a sale deed in favor of defendant number 2. Lord, the first question that would arise for consideration is the finding that is recorded by the director and the evidence that is on record. Defendant is in possession of it. When defendant is in possession of the property, declaration and injunction is not the proper way.
Where is the finding?
Trial court finding and paragraph 23, page 62.
Yes, please.
On perusal of document exhibit D1 photograph, it is marked through confrontation during the examination of video. Later on, again marked exhibit D1 for Panchayat of the food property marked by the defendant number 2 during the chief exam. Though the plaintiff during the cross-examination admitted the photograph shown by the defendant's counsel that the house property shown in the photograph is the house of the defendant. As already discussed above, defendant number 1 entered the names of grandfather for defendant number 2 and their family members on the same day. So the defendant, without having any right to own the property, constructed the house in property. But even PW2, who, according to the plaintiff, had mediated, has stated that he has advised the defendant to give up possession of the property in favor of the once, my lord, the defendant possession is admitted, declaration and injunction is not the proper remedy. The suit is not maintainable under section 34.
What is the total extent of land?
That is, my lord,
57 by 15.
Yes. It's a house property. But even, my lord, the plaintiff has not proved how the property has come to them. The partition is not proved.
The vacant site.
It's a vacant.
Full. Admit all for records. The question of law. substantial question of law which arises for consideration in dispute is whether in this appeal is whether the trial court and the first appellate court committed an error in entertaining a suit for mere declaration injunction without the plaintiff seeking for possession of the suit property, in the light of the findings recorded in the trial court that the defendant number 2 had constructed a house for the suit real property. Party shall maintain status quo of the property until disposal of this appeal. The issue notice, I think, admit issue. Yes, Mr. Kumar. Yes, what happened? The learned counsel for the appellant submits that the appellant is submits that in view of the decree granted by the trial court in invoice number 311 or 13, and in view of the share of the plaintiffs declared in invoice number 9 of 2006, the appellant is willing to proportionately divide the commission payable. No, whatever you want to do, make her as a party to the dealership. No, then he will not consent. Why will he consent? No, that we cannot have too many knots. If you are taking the responsibility of paying the commission to all these people based upon the final decree proceedings, we will grant you time. So then that cannot be done. This is an appeal filed by the defendant in invoice number 311 of 2013. No, but how can you? The dealer will not accept. Dealer is somebody. Dealer is not a member of the family. Dealer is not a member of the family. So now you have this dealer and this Sampath Kumar has entered into lease agreement. Dealer with you, and so therefore the rent that you are paying to Sampath Kumar is very minuscule. 10,000 rupees, 1,000 rupees ಅಂತ ಹೇಳ್ತಿದ್ರ per person. How does it? Who will accept it? The dealer is going to get the larger income. You please, we'll dismiss this. You work out your remedy. Issue notice. So Dhananjay Joshi. It is for partition. ಏನಾಗಿದೆ? Yes, please.
Most of the property which is for on page 44.
Yes.
Because we discussed for in respect of most of the property except to B. I am affected by that and therefore I want to waiting on my challenges.
Appeal was filed by the
is filed by defendant number 1. Plaintiff claimed a share in respect of several scheduled properties.
Yes.
He has succeeded only in respect of Schedule B, of which I am agreed.
Yes.
He has lost in respect of all the other scheduled properties.
Yes.
And he has not challenged this dismissal.
Yes.
In fact, the lordship will find at page 5, undisputed facts that our father was the owner of land in survey number 64/6 and other land also. They are concerned only with this. There was a partition within the family member after his demise on 8 July 1980. Sister partition. 8 July 1980. Under which Schedule B went to the plaintiff, Schedule C came to me, Schedule D went to another brother. I purchased Schedule D from my brother on 29/6/1984. It is my case that I have also entered into an agreement of sale with my elder brother, that is the plaintiff. I have entered into possession, paid in consideration, and I bought a khata in respect of Schedule B, my name. He denies it. Both the courts notice my agreement of sale. Both the courts take notice of my exhibit D2, which is the revenue entry where he has come and acknowledged that he has sold the property in my favor. He has received due consideration, etc. But both courts lose sight of section 53A of the Transfer Property Act and hold against me on the only ground that there is no registered sale deed between the plaintiff and
The possession was delivered.
possession was delivered. I have produced the agreement of sale and his own statement. His statement is marked as exhibit D2.
No, just read that agreement.
Agreement is produced. People again, the agreement, though listed as to be produced in the evidence, was not produced there. I find an application here. It is referred to by both the courts.
Yes.
Either negligence or mischief, I do not know what. But it is referred to it. The judgment is referred to
Only the additional evidence.
one of 2020.
ಎಲ್ಲಿದೆ ಅದು ಶೆಡ್ಯೂಲ್ ಇಲ್ಲ ಇದಕ್ಕೆ ಕರಾರು ಪತ್ರ ಶೆಡ್ಯೂಲ್ ಇಲ್ಲ ಎಲ್ಲಿ This is a possession.
Pursuant to this exhibit D2,
I'll read out this agreement for your convenience.
I am familiar with the agreement. The word possession does not come.
Then
it only says that it is agreed to select and it's a full sale agreement. Then after that exhibit D2, I only remember circumstantial evidence directly. There is nothing from me to say that possession has been handed over.
53 ಏನಲ್ possession ಅದಲ್ಲೇ ಕೊಡಬೇಕಲ್ಲ.
Exhibit D2 records of that. When he comes before the revenue authority and acknowledges the ownership of the property.
Yes.
Where
53.
Where any person contract to transfer for consideration any movable property by writing signed from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty. And the transferee has, in part performance of the contract, taken possession of the property. I have.
No,
He
no.
does not need to give it to me writing.
It should be under the agreement.
No. That's a different. Where any person contracts to transfer for consideration any movable property by writing signed by anyone from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty. I pause here. The document should be such that the terms of the transfer must be ascertained. Subsequently, which need not be a part of the document, and the transferee has, in part, performance of the contract, taken possession of the property or any part thereof, or the transferee be already continued. The factor of possession need not be in writing, but should be in pursuance.
It should be in writing. It should be in writing. It should be in writing. One of the conditions ನೋಡಿ ನಾಲ್ಕು ಬನ್ನಿ.
And the transferee has in part performance of the contract taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of the contract and has done some act in possession of the contract. And the transferee has performed or is willing to perform the contract. These two is proved by exhibit D2. Then, notwithstanding that, that reference to registration. However, there is an instrument of transfer that the transfer has not been completed in the manner prescribed therefore by the law for the time being. The transfer of any person claiming on the right shall be debarred from enforcing against the transfer in persons claiming on the right in writing respect to the law. So what is required is one, a document in writing which from which the terms of the same can be ascertained. And thereafter two actions.
Yes.
One in furtherance thereof, I should be in possession. And secondly, he should also have done something to show willingness. I have taken possession and he has subsequently come. Because we will also see exhibit D2, it was recorded, a mutation entry. When he comes and makes a statement before the revenue authority, he says, yes, I have done. But we need all the ingredients of section 52.
Whether the document relied upon by the defendant number, document relied upon by the defendant number 1, under which plaintiff purportedly sold the B schedule property to the defendant number 1 could be whether the will be pressed into service to claim the protection under section 53A of the Transfer of Property Act 1882. Question mark. If yes, whether the suit filed by the plaintiff for partition of the Schedule B property was maintainable against the defendant number 1. Yes, paperbooks to be filed within 8 weeks. The drawing up of final decree in respect of the B schedule shall remain state during the pendency of this. Okay, drawing up of final decree is state. Yes. A suit for perpetual injunction. Permanent injunction yellow illa madam, perpetual injunction anta no. Permanent injunction anta helbedi. Perpetual injunction.
For the original owner of the food property and that they had executed give the in the same in favor of the first principal on 16/1994.
Issue notice. Let me walk with
Number 38, Sidmalappa PM.
Sidmalappa. Mr. Sidmalappa. ಹೇಳಿ ಸರ್. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Sidmalappa PM.
Please, Malak.
ಒಂದು ಲಾಗೌಟ್ ಮಾಡಿ ಒಂದು ಡಿವೈಸ್ ಸರ್ ಒಂದು ಡಿವೈಸ್ ಲಾಗೌಟ್ ಮಾಡಿ ಸರ್, ಇಲ್ಲಾಂದ್ರೆ ಎಕೋ ಆಗ್ತಾ ಇರುತ್ತೆ. ಹೇಳ್ರಿ
ಪ್ಲೀಸ್ ಮಲಾಡ್. Please, my lord.
Yes.
Not appeal by the first defendant. Not suit filed by the by one Sampangi Ramachari. for perpetual injunction with respect to agricultural land bearing survey number 113/1A,
Yes.
measuring 2 acres 2 guntas
Yes.
of Korti village.
Yes.
Lord, the defense, the trial court dismissed the suit. Trial
Yes.
court dismissed the suit on merit. Lord, the LRs of deceased plaintiff preferred appeal. Appellate court reversed the judgment and ordered to decree this. The claim of the plaintiff is that suit share property originally belongs to one Dodda Nanjundachari.
Yes, what
Who is the
happened to the
father?
earlier?
Who is the father of plaintiff?
The 156 of 97 ಏನಾಯ್ತು?
That suit is pending. That suit is pending.
Yes.
Lord, that suit was filed based on Lord agreement free conveyance dated 21/1953.
Executed by your father.
Executed in favor of the father by dependent's father. Lord, my submission is under the registered sale deed dated 25/10/1953, property was sold in favor of the father of the plaintiff, this defendant.
We will issue notice, divergent finding.
Divergent finding ಮತ್ತು ಅವ್ರು reconveyance ಕೇಳೋದು reconveyance deed 9 ತಿಂಗಳು ಮೊದಲೇ ಸೇಲ್ ಡೀಡ್ ಹಾಕಿನ ಮೊದಲೇ.
Correct, but 156 of 97 ಏನಾಯ್ತು ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ, ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಹಾ,
ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಆ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಈ ಸೂಟ್ ಹಾಕ್ತಾರ ಅವ್ರು. ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಎಂಟ್ರಿ ಮಾಡೋದು ಸಿಗಲ್ಲ. ನಾಟ್ ಟು ಕಟ್ ಅಂಡ್ ರಿಮೂವ್ ದಿ ಯೂಕ್ಲಿಪ್ಟಸ್ ಟ್ರೀ ಅಂತ ಕೇಳಿದ್ರು. ದಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ by holding that they have not proved their prima facie case.
Notice.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಒಂದು ಸ್ಟೇ ಬೇಕಾಗಿದೆ. ಸ್ಟೇ taking advantage.
Party shall maintain status quo in respect of the property in question till the next date of hearing. Yes. Yes, Mr. Sidmalappa, serial number 39. Number 39. Status quo ಮಾಡಿದೀನಿ 39 ಬನ್ನಿ.
Please. What serial number 39? Appeal by the plaintiff.
Yes. Yes.
Suit for partition and allotment of share claimed by the plaintiff.
Yes, sir.
But suit share properties are Lord ancestral property of Chennaya alias Channappa of Uskur village. Lord Chennaya had a wife Srimati Vannamma. They had 3 sons and a daughter. Shivrudra is the first son, who is none other than the father of the plaintiff. Vanna Gangaya, father of respondent number 5 and 6.
The plaintiff antira, respondent antira. ಅದಕ್ಕೆ ಹೇಳೋದು.
I'm sorry. Defendant number 3 and 4. Defendant number 3 and 4. Sorry. But the Siddhalingaya and his wife Srimati Parvatamma died issueless. Ultimately, the property requires to be devolves on Shivrudraya and Vannagangaya, daughter Vannagangamma.
Yes.
The defense, they have taken a defense saying that there was a partition.
Yes.
No reference with respect to date of partition, no materialization of partition, no evidence in proof of partition except referring to revenue record. Revenue record, both the court says revenue record stands in the name of defendant. For that reason, I am not entitled for partition.
I am for respondent, my lord.
Yes, what happened? Yes.
My lord.
Yes, Mr.
My lord, last evening they had called and they have not spoken anything about the settlement. Only
Yes.
they have told that we cannot give the property. That's what the thing was spoken, my lord. And we are confined to the word given by the honorable Justice, my lord.
Yes, Nale Barakeli, court. Ask your come tomorrow morning.
Yes, my lord.
Tomorrow. Sorry. Please argue. Please argue. Yes. Yes. Whole contesting between respondent number 4 who was arraigned and defendant number 4 contention of oral partition that was put forth by defendant number 4 extended by the High Court and by the first court. Let us read the finding. First go to the trial court, Mr. Please come to paragraph number 22 of the trial court judgment. Para 22 of the trial court judgment, ink page 74, internal page 15 of the trial court judgment. According to the evidence given to the family as per exhibit 1, this document is flawed. It is a schedule and it discloses several properties were followed to the state of legal. This document does not disclose about the partition of the property. However, this document was not for collateral purpose and not to do maximum partition. Reported in the AR 2008. An unregistered policy cannot be treated as memorandum and she cannot require decision. Further, in view of the decision reported in INR 2000 Karnataka page 395, an unregistered policy can be looked into for collateral purpose for ascertaining the intention of co-partners to become divided in shares and to know surveillance of the status. Thus, in view of the aforesaid principle of law, exhibit B1 can be taken into consideration for collateral purposes and not for any other purpose. Exhibit B1 has also not examined any witness to do the document and to prove the matter of the partition. Yes. Exhibit B1 has also produced certified copy of the registered statement dated 21/2012 on the result of the said document. It reveals that the plaintiff and his family members have sold the order in favor of others. At this stage, I would like to narrate the recitals of the said document which reads thus. Schedules to Namagala Pitrajika Sansadigu ಒಂದನೇ ಮಾರಾಟಗಾರ ದಿನಕರ್ ಆದ ನನಗೆ ವಿಭಾಗದ ಮೂಲಕ ನನ್ನ ಬಂದಂತಹ
ಗೊತ್ತಾಗಿದ್ದು ನಂತರ ನನ್ನ ಹೆಸರಿಗೆ ಈ ಕಾಗಿಯಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಕಚೇರಿಯಲ್ಲಿ ಖಾತೆಯಾಗಿದ್ದು ಇದುವರೆಗೂ ಸಂಪೂರ್ಣ ನಮ್ಮಗಳ ಹಕ್ಕು ಮಾಲೀಕತ್ವ ಹಾಗೂ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ
Admit the substantial question of law which arises. Admit issue notice. The substantial question of law which arises for consideration is appeal is whether the courts, whether both the courts committed an error in construing, in considering exhibit D41, exhibit D41 for collateral purposes under section 59 of the Karnataka 49 of the Registration Act 1908. Notwithstanding the fact that the said document was not duly registered, next, whether both the courts committed an error in holding that the defendant number 4 had proved oral partition. Paper books to be filed within 8 weeks.
By the defendant number 3. Israel in the year 1972-75 acquired several properties to partition this area. And subsequently on 96/1998, we read and plaintiff and defendant as his last. And on 7/8/2013, we created the order files are sold for partition and separate against the defendants at OS number numbers. OS number 7 of 2013. Usually the trial court, my lord, granted 1/4 share in our court. And later the defendant number 2, the defendant appellant, prefers an appeal before the senior civil judge, my lord, at earlier number 40 of 2018.
Why did the trial court grant a decree in respect of all the respect of 1/8 share? Or where is the genealogical fix? 72. The 1/8 thing ಕೊಡ್ತಾರೆ. How did the trial court grant 1/8 share?
Trial court order. Page number
72 is family tree is at page number 72. Please go to family tree. Basama, Chandrama, and Muttappa and Channappa. Even if you apply 2005 Act, it is 1/4 share. How did the trial court grant 1/8?
Paragraph number 20 of the trial court judgment. Page 60. It went on stating that the earlier, as already said, the plaintiff is claiming to be entitled for 1/4 share interest as the class 1 heir of her father Channappa. Is the specific case of the plaintiff that her father Channappa had died on 9/6/1998 by leaving behind herself and the parents as his age has to succeed his estate. That fact is not at all in this case. Here as contesting judgment, defendant number 3, the death of his father Channappa. Now the amendment brought to this section 6 of the succession act 2005 had given equal right for daughter of a co-partners that of a son of a.
So Prakash versus Pulvati is gone. So Vinita Sharma ಬಂದ್ಮೇಲೆ ಏನಾಯ್ತು?
That is my point in this case. This suit was decreed for 1/8 share in the year 2019. So that is on 17th September 2019. Till the Vinita Sharma case was judgment was pronounced, no election record, activity was being referred by the end of the not by the plaintiff activity as the appeal by the defendant is not done. As soon as the Vinita Sharma case has been pronounced by the honorable judge. Immediately the plaintiff because an appeal before the civil judge.
What's wrong?
Senior civil judge.
What's wrong?
That too because that too with the delay, my lord.
So what?
Yes, my lord. But in the appeal judgment, my lord, kindly listen. At page number, yes, my lord, page number 31.
Yes.
The appellate judge, the lower appellate judge has extracted everything in the legal system. Last of every findings of the honorable.
Yes.
The major extract has taken in that because all the suits appeals pending in the High Court and subordinate court. That is my point.
Yes.
At the filing of the RE before the Supreme Court and the order, no appeal was pending. Even at the time of pronouncement of judgment of 27, no appeal has been preferred by any of the parties. Now the activity was present before any of the court.
Yes.
After the pronouncement, after nearly 1 year of delay, this appeal has been preferred and stating in the ground that this is against the established the judgment and degree given by the lower court. This is against the established principles and proceedings of the lower.
Yes, purple. This appeal is filed by the defendant number 1. Invoice number, sorry, appeal is filed by the defendant number 3. Invoice number 117 of 2013 on the file of the Principal Civil Judge and Kodalkere, challenging the judgment and decree dated 17/9/2019, which was confirmed by the first appellate court in RA 51 of 2020 by judgment and decree dated 24/9/2021. Stop. Next para. The suit for partition separate possession of the suitable properties was filed by one of the daughters of Channappa. Channappa is dead. Of Channappa, of deceased Channappa. Full stop. The defendants were the daughter, wife, and son of Channappa, respectively. Full stop. The suit properties were claimed to be joint family ancestral properties. The plaintiff alleged that the defendants had refused to
Understand of the plaintiff is that I am not dependent on the control of the property and I really need property.
Is that after the death of her father, the defendant number 3, in collusion with the defendant number 2, were not rendering proper accounts, and they are attempting to alienate the suit properties by getting their names entered in the revenue records. So this suit was contested by the defendant number 3, who did not dispute the relationship. He claimed that he had improved the suit properties and had constructed a house. He improved the suit properties and also the house and also developed the house property, developed the house on the property, and had invested enormously by raising loan from various sources. He therefore prayed the dismissal of the suit. Next para. The trial court, after considering the oral and documentary evidence, held, applied the law as it stood prior to Vinita Sharma, and declared that the plaintiff is entitled to 1/8 share in the suitable properties. On an appeal preferred by the plaintiff, the first appellate court relied upon the judgment of the apex court in Vinita Sharma and declared that the plaintiff is entitled to 1/4 share in the suit shall properties. Actually, 1/4 ಬರಲ್ಲ 1/3 ಬರಬೇಕು. 1/4 plus 1/12. 4 3s are 12 plus 1 4/12 1/3 ಬರಬೇಕು. ಮಾಡ್ಲಾ? ಇವಾಗ ಅಪ್ಪ ಸತ್ತೋದ್ರಲ್ಲ ಚೆನ್ನಪ್ಪ. ಕರೆಕ್ಟ್. ಚೆನ್ನಪ್ಪ ಸತ್ತೋದ್ಮೇಲೆ ವಾಟ್ ಶುಡ್ ಹ್ಯಾಪನ್ ಟು ಹಿಸ್ ಶೇರ್? ಚೆನ್ನಪ್ಪ, ಚಂದ್ರಮ್ಮ, ಬಸಮ್ಮ and ಮುತ್ತಪ್ಪ 1/4 each. So 1/4 plus 1 2 3 4 1/16. 16 4 4s plus 1 5/16 ಆಗುತ್ತೆ. 1/16 will go to ಚಿತ್ತಮ್ಮ. Yes. ನಿಮ್ಗೆ ಇನ್ನ ಕಡಿಮೆ ಬರುತ್ತಲ್ರಿ ಹಂಗ್ ಮಾಡಿದ್ರೆ. If you apply Vinita Sharma, you will get less. No, if Vinita Sharma has to be applied now. If Vinita Sharma is applied, then you will get 1/4 ಕಿನ ಜಾಸ್ತಿ ಕಡಿಮೆ ಬರ್ತದಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ ತಾಯಿನ ಒಳಗೆ ಹಾಕೊಂಡ್ರೆ ಹಾಫ್ ಆಗುತ್ತೆ ನಿಮ್ಗೆ. ನಿಮ್ ತಾಯಿ ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡ್ರೆ ಅರ್ಧ ಸಿಗುತ್ತೆ. That is right, but please consider, otherwise we have to rework the shares. Next week ಅಲ್ಲ, tomorrow. Either withdraw it. Withdraw ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಕಡಿಮೆ ಆಗುತ್ತೆ. ಲೆಕ್ಕ ಮಾಡಿ 1/4 1/4 1/4 4 ಜನಕ್ಕೆ. Channappa's 1/4 will have to be again divided between 4. So you will get plaintiff will get 5/16, more than 1/4, and your mother will only get 1/16. At least ಇವಾಗ 1/4 ಬರ್ತಾ ಇದೆ ನಿಮ್ ತಾಯಿಗೆ. ನಿಮ್ ತಾಯಿ ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಆ 1/4 ನಿಮ್ 1/4 ಬರುತ್ತೆ, ಅರ್ಧ ಬರುತ್ತೆ ನಿಮ್ಗೆ. ತುಂಬಾ ಎಷ್ಟಿದೆ? See number 8. What happened? Why was it? Yes, Mr. Ravi Shankar. Yeah, Ravi Shankar. There's no representation.
Lord, sir.
Yes, please.
On serial number 22, I'm appearing for the Petitions Council.
We're at serial number 8.
Sorry, Lord. Sorry. 8 minutes. I'm appearing for the Appellants Council in this matter. Lords, your Lords, while granting an interim order, are directed that I have to pay 5,000 rupees per month from the date of the suit.
Yes.
Lords, I will pay 50% of the amount, Lords, within 4 weeks. And your Lords may list this matter for further orders after 4 weeks, Lords, by recording my statement. Because it's COVID time. Lords, what happened? There was an unconditional, please.
The Learned Senior Counsel, Mr. D.R. Ravi Shankar, seeks time. Learned Senior Counsel, Mr. D.R. Ravi Shankar, representing the appellant, seeks time of 4 weeks to deposit the rent as ordered by this court on
50%. 50% I will deposit within 4 weeks. The Lords may list it for further orders on.
To deposit 50% of the rent as ordered by this court on 7/4/2021, and agrees to pay the deposit the remaining 50% by.
Well, Lords, I'll make a submission on the next hearing because
on by the next 4 weeks. Within 4 weeks thereafter.
Thereafter, please.
Yes, it is made clear that if the interim order dated 7/4/2021 is not complied, The respondents are at liberty to proceed with the execution in execution case number 353 of 2019. Yes.
Please, Vilas.
Yes, please. Sorry, Mr. You can't. Please come up with the facts. Let us see. Sorry. No, sorry. It's not listed today. It will come day after tomorrow only, obviously. So please argue. Let us see if there's anything we'll consider. No, sorry. We are not adjourning any case. I can't make an exception to you. Please come up with the facts. Let us. Please give a few facts. Yes.
What has happened, my lord, is that the appellant had purchased the property bearing number 291 of 56 in Vidati Okli, Ramnagar district, from the respondent 326.
Yes.
Now, respondent number 2 was the vendor of respondent number 326.
Respondent number
2 was the respondent 326 are my vendors.
just a respondent number 326. They are your vendors.
Yes, respondent number 2, my lord, is the vendor of respondent number 326.
Respondent number 2 is the vendor.
Of 326.
And you purchased from 326.
Yes, madam.
Yes. When did you purchase?
My lord, I purchased it in the year, my lord, 1991.
1991.
Yes.
Yes.
What had happened is this, madam. Respondent number 1 and respondent number 2 had entered into an agreement of 1983.
1 and 2.
Yes, madam. But for some reason, madam, dispute arose and the respondent number 1 initiated a suit of specific performance.
Yes.
During the pendency of that suit, madam, the respondent number 2 sold the property to respondent number 326. Subsequently, madam, I had purchased the property from respondent number 326 in the year 1991. But the suit ultimately came to the victory in the year 1988. The suit came to be victory in the year 1988, and thereafter an execution petition was also filed. That is, execution petition fell off 1988.
I have some disability. SPR group, right? Not with you. I filed a case against this man. His son and his SPR group, I think they are warring against each other, isn't it? I was representing the son, Raghavendra. Yes.
Appearing for respondent in this case.
Number 23.
Yes, appearing for respondent in this case. On several occasions, matter was listed.
So it is called twice in the day. This appeal is dismissed for non-constitutional. Yes. Tandrala file. ಹೋಗಿ ತಗೊಂಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. No, don't be under the impression that you will get an adjournment just like that, Mr. No, this is coming up before me for the, I think last time ಬಂದಿತ್ತಲ್ಲ. ಮತ್ತೆ tomorrow. Yes, next.
Appearing for the appellant.
Yes, please.
May I please, ma'am? Now your lordship may.
Respondent pass ಬರ್ಬೇಕಂತೆ. Yeah, ಅವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ. Yes, yes, sir.
Lord, now I come to the substantial question of law. It is framed by this humble court. Lord, whether the court below your lordship,
yes,
having rejected the claim of the defendant that there was a partition between the ancestor of plaintiff and the defendant 50-60 years prior to filing of the suit, is justified in accepting the plea of the plaintiffs that the suit scheduled property was jointly allotted to the share of the ancestors of the plaintiffs and defendant, Dasappa and Karyappa, in the partition between the children of late Allappa and order for partition of the same between the said two families in equal share in the absence of pleadings and evidence in that regard. Lord, the dishonorable court, my lord, noticed that the partition was rejected so far as this Karyappa is concerned. And having accepted the earlier partition between the other brothers, in the absence pleading that with regard to why it was done so, and having aware of the fact that the property was not allotted to them in the 50-60 years back, their ancestors are not at all filed any suit for partition and separate question, questioning for not allotting the share till 89 up to third generation. And having rejected that plea, again the court says that there was a partition, but there was no partition between Dasappa and Karyappa. So both the court says two ways. The court records the finding that there was a partition 50-60 years back. But whereas it comes to the plea of the plaintiff, it accepts that there was no partition. When and between the Allappa's children, Allappa's sons. Having said so, whether the courts justified in accepting such a plea, inconsistent to each other. And in the absence of pleading, it's in support of that, and with regard to how it was left out him at the time of partition. And moreover, I already pointed out to your lordship, Karisangappa get 10 acres and Allappa, that is 4 sons, your lordship, that Allappa had got 4 sons.
Yes.
One is Dasappa, Karisangappa, Allappa and Karyappa.
Yes.
Both were there at that time. And if the property belongs to the Allappa, these are the sons. Why the property is not allotted to the share of Karyappa? Why it was left out?
Yes.
Their case is now developed is that it was jointly allotted. What is the thing? If it is a partition, once it is set up, together share. 3 persons have taken share. Only one person says that they jointly allotted. Why not with Karisangappa?
Yes.
So therefore, this our court has framed this substantial question of law, whether the courts below, having accepted the partition, again saying that there was no partition between the plaintiff's family, plaintiff's ancestors and dependents' ancestors.
Sir, don't repeat it, sir.
Please
proceed. Don't repeat it.
As well. Therefore, my submission to your lordship is both the courts below, having noticed without taking these factual aspects into consideration, passed the judgment and decree in favor of the plaintiff, which he comes having knowledge of the fact that there was a partition.
Yes.
And this fact is supported by the documentary evidence. Documentary evidence itself speaks. The partition was there. Their case is that it was allotted to Dasappa and Kariyappa. What is this? There is no material at all. Therefore, my lord, my submission to your lordship is both the courts below, having accepted the earlier partition, it not have been again partition the property. Between the only ancestors of plaintiff and the defendants.
Yes.
So under these circumstances, your lordship, to prove that fact,
yes.
In this regard, I would like to draw your kind attention to the division bench judgment of the Istanbul Court.
Yes.
In Mallappa and others versus Mallappa and others. In RFA,
Mallappa and others, yes.
Reported in 2014. 4 Mela. ACCR 581 Mela page. The substance of that this one is law laid down by the division bench of the Istanbul Court is plaintiffs proving the genealogy but not establishing the fact that propositors had properties in order to form a part of joint family. The individual members want to be cultivating the land in their individual capacity held. Those properties cannot be claimed as those property of joint family.
Yes.
Therefore, my submission to your lordship is both the courts below proceeded on the assumption that there was no partition, only portion of the ancestors' family. That is impermissible under law. When the facts establishes that there was already a partition.
Yes.
If there is a case, they have to sort for a clear partition, making all the branches of the Allappa as a parties to the suit, and they have to claim the share. Not only the Dasappa's branch.
Yes.
Therefore, my submission to your lordship, both the courts are heard in decreeing the suit, and I pray for allowing this appeal.
Yes, madam. Madam. This tomorrow.
I hope I have completed within 20 minutes.
Oh, you have given me 10 minutes back.
Thank you, Malad.
Yes, Mr. Ravindra Prasad.
Number 54, Ravindra Prasad.
J. Ramesh.
J. Ramesh for responding.
Yes. Next.
Number 55, Insurance Trading.
Yes. Miss ಆಯ್ತಲ್ಲ ಬಸ್ ಮಿಸ್ ಆಯ್ತು. Yes. No, please wait. Yes. Yes. Yes.
Referring to it is only Purappa who had no children, he had given consent, mother had not given consent. I was referring to a lordship with respect to D1, D3, D4. There, mother had filed the application before Assistant Commissioner for change of property in the name of property to be rotated in her name. That's how she mentions with respect to 3 properties. And then an affidavit was filed. I refer to lordship. Your lordship posed me a question whether this is confronted and proved. At that stage, I submitted whatever the work value is. Now I will take your lordship through the evidence of everyone. Everyone. Page 126 of paper. The purpose for which these documents were produced is
Yes.
she had given consent.
Please give me a minute. Dharwad file sign ಮಾಡ್ಬೇಕಂತ somebody is going to Dharwad. Yes.
Page 128, paperwork. 126. One. Krishna Reddy. He was examined. He speaks. ನನ್ನ ತಂದೆ ತೀರಿಕೊಂಡ ನಂತರ ಅವರ ಸ್ವತ್ತುಗಳ ಬಗ್ಗೆ ನಾನು ಯಾವುದೇ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲಿಲ್ಲ. ತಂದೆ ತೀರಿಕೊಳ್ಳುವಾಗ ಜಮೀನುಗಳ ಖಾತೆ ಆಗ 20 ಸ್ಥಿತಿಯಲ್ಲಿ ಕೂಡ ಬಂದಿದೆ. ನನ್ನ ತಾಯಿ 5/8/90 ಸರ್ವೆ ನಂಬರ್ 199 ಜಮೀನುಗಳಿಗೆ ಅವರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಕೊಡಬೇಕೆಂದು ತಹಸೀಲ್ದಾರರು ಕೊಟ್ಟಿದ್ದು ನನಗೆ ಗೊತ್ತಿದೆ. ಈಗ ನನಗೆ ತೋರಿಸಿದ ದಾಖಲೆ ಅವರು ಕೊಟ್ಟ ಅರ್ಜಿಯ ದೃಢೀಕೃತ ನಕಲು. ಎಕ್ಸಿಬಿಟ್ D2 ಸಹ ನನ್ನ ತಾಯಿ ಕೊಟ್ಟ ವಂಶವೃಕ್ಷದ ದೃಢೀಕೃತ ನಕಲು. ಎಕ್ಸಿಬಿಟ್ D1 ಫಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್. ವಂಶವೃಕ್ಷ ಎಕ್ಸಿಬಿಟ್ D2 ದಾಖಲೆಗೆ ಮೊದಲ ಪ್ರಥಮಾದಿ ಸಹಿ ಮಾಡಲಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. ಈಗ ನನಗೆ ತೋರಿಸಿದ ದೃಢೀಕೃತ ನಕಲು ಎಕ್ಸಿಬಿಟ್ D1 ಅರ್ಜಿಯನ್ನು ಕೊಟ್ಟ ಕಾಲದಲ್ಲಿ ನಾನು ಮತ್ತು ಇತರರ ಕೊಟ್ಟ ಪತ್ರ ಎನ್ನುವುದು ನಿಜ. ಸಾಕ್ಷಿಗೆ ತೋರಿಸಿದ ದಾಖಲೆಯನ್ನು D3 ಎಂದು ವಿಶ್ವಾಸಿಸಲಾಗಿದೆ. D3 ಪ್ರಮಾಣ ಪತ್ರಕ್ಕೆ ಮೊದಲ ಪ್ರತಿವಾದಿ ಸಹಿ ಮಾಡಲಿಲ್ಲ.
So this is confronted. D1, D2, D3 are confronted. This witness accepts. Therefore, here is a case where this D3, the affidavit sworn to, is signed by Muna Reddy, is an appellant, Krishna Reddy, appellant, Lakshman Reddy, his brother, Veera Reddy, brother, Papamma, the mother, and Venkatamma, co-relations. All these are signed and sworn to this affidavit. Yes. My submission is, father has signed exhibit D60. They have pleaded about exhibit D60. They have admitted the existence of exhibit D60. They have pleaded for some other purposes. It came into force. It is a registered document. The site is in a registered document by oral evidence cannot be taken. I have stated a judgment. Therefore, here is a case where under exhibit D60, the past event of adoption is accepted. It's recorded. It's registered. Father has signed. Mother, she eliminates his son to get the share. That means Gautam with respect to the father's property. My submission is, she knew that there was such adoption. She had consented, his wife, herself and husband had accepted it. Therefore, now by coming before the court, she is they read already, they have read that portion of the AW2 evidence that will not hold. For simple reason, at the point of time when there was no dispute at all, she has presented such petition. That clarifies that she was aware that event which took place in the family of adoption. Substantial person of law 1, 3, and other substantial persons of law, they all revolve around this exhibit D60. Now I go to the reunion part. There are 4. He pleads. Plaintiff pleads. There are 5. There are 5. That there was division, though that there was division.
So where are you reading? Para 5 of the plaint. Para 5 of the plaint.
Yeah. There is the grandfather of the plaintiff, that is Mohammed, and his brother Surappa. Though there was a division of the properties amongst their brothers, we joined together and lived as co-heirs of Hindu joint family. So here is 2 things. One, division. Division is accepted by them. So reunion is to prove. It's a fact which they pleaded. For the purposes of proving of reunion, my expert submission is co-partners can reunion, but not the wife of a co-partner. I will cite the big of High Court. Again, the
yes.
This is a violent issue. Two Karnataka law. The reunion is very occurrence. When split by the party, so this establishment by order, dimension, and unnegotiable evidence is not able to the still members of the community afterwards. You will have around this what happened if you are there. Our person is very happened. Subsequently, here there is that. Is what one of the SPL members of the around this is further established by convinced parents that they had the intention to alter their status to revert back to the status of the ambiguous piece of conduct equally consistent with the union, ordinary joint employment not sustainability of the union. The mere fact that the separated persons choose to live together or live jointly for the purpose of business or in their business with purpose will not give them the status of persons unless there is further intention to implement. The distinct feature of reunion is not merely living together or carrying on trade or business together, but the intention to revert back to the status of personality. The intention of unity in existence and interest. It is well settled that the very hallmark of personality is unity of possession and community of interest. The person who wants to union must successfully establish, but necessarily establish by cogent and reliable evidence that the intention of the members was to bring about such unity of interest in history. There is no such. There is clear rejoined, but no evidence is obvious. Next, our 13. In 786. Yes. It is well settled that the proportioners after severance of status in the partition can reunite either all or some of them, and thus become reunited in a state and interest. So that is like in 25 Calcutta that ALR, Balda versus so and so. It's held that the reunion is in a state and property, so-called economic actors between persons or marked to the original partition, it's proportionals. The reunion thus can take place between persons who are parties to the original partition. It is true that the commandants are not unanimous on the point. According to Hitachi, Daimara, and Srutichandrika, the member of a joint family, once separated, can reunite only with his father, brother, or paternal uncle, but not with any other relation. As for instance, paternal grandfather or paternal uncle's son, no such relation was a party to the original party. According to the Murray Chintamani, in the Telecast and the Mayuka, the person may unite with the relation was a party to the original party. Only males can unite, not female member. That's Karnataka versus the other paragraph also to that extent, ordinarily joint enjoyment cannot sustainably a union. That's in next page. Page 15 only, second para. What is stated about? Yes. My submission is in the print itself, the year of reunion is not mentioned. Even the two has not stated about it. Simply they say, what happened to Nadilla, submission is display also not going to come to the court. Next is with respect to which properties fell to the share of Gurapa, which properties fell to the share of property is not clearly stated by PW. I have stated so many properties, 1 to 10 fell to so and so, they are not included. So and so are be set up by them. So and so are the properties of property. All that is stated. Lower court and first of the court, they have accepted. With respect to that, my submission is merely if they say, naವೆಲ್ಲ ದುಡಿತಾ ಇದ್ವಿ, ತಗೊಂಡೋರು ಕೊಡ್ತಾ ಇದ್ವಿ, yes, ಯಜಮಾನ್ was the eldest member of the family son. That's not sufficient enough for the purposes of proof. My submission is here is a case where joint family, joint status, if they say, then he is the duty, that is the burden cast upon the person who feels properties in the name of other person. All the self-regard, the joint family properties. The burden is discharged under section 100. Then alone, bonus shifts on the others. That's so in B.S. Lakshmaya's case of 2003, this is stated. Earlier also, upper Swami's case and 54, Srinivas Krishna Papa's case also is stated. If that is not proved, clear submission that we were getting in the paying to him, he has purchased this. That's all joint family property. It's not self-employed property. It's not purposeful.
Sufficient nucleus. This is a settled position of law. Sufficient nucleus.
Sufficient nucleus to be created, and they must in this statement it said in the nucleus with joint family of one crore. If it does not need, then cannot be this. That's one of the here they say yes, we were running. How can support that? How can support? They are website one thing. So if he gives credible good, yes, credible one gives. This question is evidence is insufficient to prove that this is the problem. Joint family before anything. Go to this substantial process.
Yes.
The manner of consideration of the first the manner of consideration of evidence, more particularly the document between these 16 has led the wrong conclusion by the client and the suit property is later leveled to or property from the first of the night. Yes, I don't want to repeat. There are 6 for which it came into force. If they failed to prove it, this is accepted. And it is a registered document, and there is presumption, admission. With respect to the mother, yes, when she applies for change of product with respect to her husband's property, she files affidavit along with other sons, excluding first son. That is sufficient in respect to which the adoption is to be accepted. The event of taking of adoption is to be accepted. Then comes second. In that view, both the courts have erred concurrently in coming to the conclusion that the property item 11 to 23 are not joint family property, not available for partition. The same answer. With respect to this order, part 1 includes 6 to 17. Short document to that. It's only expanding it.
Yes,
yes. And then the documents produced are also only 3-4 enumeration forms. That's voters list. That will not do anything. When I go to this, other substantial questions of law raised on 11/7/2019. Whether the adoption of robbery into the family of Kurappa was a valid one. Here is a case where I have not come before the court for a declaration that I should be declared as an adopted son of Kurappa.
Yes.
Who have come before the court? Who have pleaded about the D60? You say with respect to registered document, the purpose for which it came into force is otherwise. When you fail to prove the purpose for which it came into force otherwise, then it is to be accepted. Registered document is to be presumption is there, that is to be accepted. And my arguments on that will hold good for this. in case they say said adoption of property is held valid, whether the family is led by property and Popaya, alias Popaya, and the family originally led by Gurappa, later they had Muniyama became common joint family. It cannot. So they submitted to a lordship already. Under the 1933 Women's Right to Property Act, she succeeds the property of husband because they believe that there was division. She holds the property as her property. Then she narrates, she states, she declares in Exhibit 16, we had taken substance of the person in adoption. When once it is to be, if they have failed to prove the purpose for which it came into force, then this also cannot be because there is no joint family.
1933 Act, whether it deals with the property of a female dying intestate. 1933 Act, does it deal with the property of a female dying intestate?
Division.
It's only for my consumption. Whether the 1933 Act deals with the property of a female dying intestate.
Much arguments are addressed on that. I'll come. So, Government of India Act, British government, central government also had right to legislate. The first promulgated Hindu Women's Right to Regulations 1993. Then that became law in 1937. That's central act. This Mysore province, they did not accept that. The judgment, Nesargi's judgment is available on our High Court basis. The two advocates who argued, Mr. Gopal, who has written Succession Act, and also Rendappa, who argued the matter, they straight away submit to the court that 1937 Women's Right to Property is not applicable to Mysore province. What is applicable in Mysore province is Mysore Province Act 10 of 1923. That is Women's Right to Property Act of 1933. This is Act 1 of 1953 as amended then 10 of 33. There it deals with section 4, how the property, the woman will succeed to the property.
What should happen to a woman's property? What should?
Here she succeeds to the property. She succeeds to because she is at second stage. That is section 4(1) subsection 2. Rightly, you have also put the person. She succeeds to the property. When after division, after the death of there was property, she has succeeded to property of Gurappa. That is at that stage. He dies in 44. She will be the owner of property. It does not say. Then automatically 56 Act came into force. And to 56 Act, it becomes absolute property of that woman under 14(1). If she dies, section 15, section 16. There, section 15, 16, there are heirs, class 1 heirs. In class 2 heirs, it is said so. And then third, second, class 2 heirs, brother, so. They relatives of her husband. That's how it is. If she has not alienated the property or no will is executed by her, if there was no such what we call adoption, then automatically section 15, 16 of the subsection. I have no hesitation in saying my submission is that to that extent. See here, she succeeds to her husband's property, it was divided. Then she remains, 44 he dies, she succeeds. Thereafter, this act came into force, 56 Succession Act. There, 15, 16, once again, if that is so. Section 8 also, there also. Section 6 and 8 of the Hindu Succession Act. Therefore, rightly your lordship's question is, if she succeeded in property, what happens to you? So I'm there. Yes. If I'm not there, what happens is the next question. There also the progress are very terrible. I submit, if I'm not there, they may come into picture, all others. But in that document itself, she intends, she desires. My submission is, in the Tupadamas case, in a will, what the courts are warranties, it's not that according to law you should decide, but sit in the armchair of the testator, then decide. If your lordship sits in the armchair of the woman, she has mentioned that expected D16. This property shall not go to the property shall not go to other sons, shall not go to others. It shall go only to property. That's a design. She has stated it. The event which had taken place. They may argue much stating that there is no evidence that there is ever. I don't know. It is for them to argue. That's how the property succeeds to her estate on her death in 1970. She dies somewhere in 1970. At that time, this succession act was in force. By submission, he succeeds to the property of that one and his self-acquired properties. Yes. He has not claimed any share in the property of property. It's not stated in the written statement. Then comes second question. That's third. Whether the property of undivided family led by property alias Papaya and originated by Gurupa are available for partition. No, they are not. Because they believe that there was division. When there was division amongst the brothers, it's property, and Siddhapa, trade issues, not in picture. Then comes only two. There was division, therefore, that's not available. Next, fourth substantial. The rights of succession of property in natural family are divested by virtue of adoption. Rightly, I have not claimed. But once adoption is there,
you are not claiming your natural father's property.
see, Swayam Shayana for adoptions, then he will have, he is a son in the natural family, he is also a son in the adopted family. That's not the case. It is not the case of the. Therefore, he will not get any right in the natural. I have not claimed that. It's not stated. And both the courts also have not granted. Property of property, they are different. My acquired properties are different. Your past properties are different. They are stated. Therefore, this whether the rights of property over the properties of family led by Gurapa are intact exclusively for Ramana. They are intact for the reason 1933 Act, the section 4.1. So three sections. I succeed to have property option. Substantial persons are. One has provided the proposed propositions submitted by the appellate Munirati, who had not filed a statement. Does not transport us. Yes. He had not filed a plea. Therefore, now he is before court. He is addressing argument. Appellant submits the as follows legal propositions. Whereas the above is for consideration. There is no legal evidence abused by the first defendant who is the option. After submitted exhibit D16, afterwards this D1, D2, D3, and it is events. Therefore, there is such evidence. You can question option. It's not valid. What is their right? I'm not snatching their property, their rights. The next bit D16, the alleged adoption deed is not an adoption deed in the eye of law, and it does not prove the fact of legal adoption. Here I take the adoption with respect to all adoptions. When there is no direct evidence, all 5 years, 3 years, 10 years, all adoptions, giving, taking, and subsequent act, it's all different. With respect to all adoptions, Devi Prasad. Second statement. L. Devi Prasad, led by Lord Sources, Timothy, Trivedi Devi and others. There, it's very clear. Devi Prasad, 1971 SCC 677. There's the 678. And so giving Roman 3. In the case of all ancient transactions, it is but natural that positive oral evidence will be lacking. Passage of time gradually wipes out such evidence. Human affairs often have to be judged on the basis of probabilities. Rendering of justice will become impossible if a particular mode of proof is insisted upon under all circumstances. They are now only pound of flesh. That's answered here. In judging whether an adoption period has been satisfactorily good or not, we have to bear in mind the lapse of time between the date of the alleged adoption and the date on which the concerned party is required to attach to. In the case of an adoption said to have taken place years before the same is questioned, the most important evidence is likely to be that the alleged adoptive father and out the person claiming to have been adopted as his son. The latter treated the former as his father, and their relations and the friends treated them as the father and son. There is no predetermined way of proving any fact. In this case, at this stage, facts in that exhibit B60, she declares you are adopted, we were treating you as our son, you did the obsequies, that's mentioned in the registered document. This is how the facts that she treated. She desires, my mother treated excluding me to get the kata in exhibit B1. Affidavit sworn to my brothers also, which is confronted and accepted, proving the fact. A fact is said to have been proved, where after considering the matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Hence, if after taking an overall view of the evidence adduced in the case, we are satisfied that the adoption period is true, we must necessarily proceed on the basis in the absence of any evidence to the contrary that it is valid enough as well. That's the judgment is based on the whole adoption, number of things. Para 10, para 11, para 12. In the same, on the same line. Document release. And regarding the position of law or current states is they must be giving, taking that is all that is reading in the last paragraph, page 685. Same that around 4 or 5 lines. That it is the best that can be said on the basis of the evidence that apart from custom differs from place to place and from community to community. It's true that in a decree made in 1970, it's also like that. Place to place, custom to custom. What is the proposition of law is with respect to that is upper community can shoot us is to be accepted as customs differ from place to place and community to community. That's what it is. Here, next question. For the child alone, without the consent of the mother, cannot give the child in adoption. The father of child alone. This proposition, which is raised. Number 3. Father of child alone, without the consent of the mother, cannot give the child in adoption, either at a customary law or statutory law. It is not statutory law, customary law. Here, this David Prasad's case, as well as her evidence, exhibit B1, B3, makes it very clear, probable that event had taken place. All the documentary evidence and the oral evidence of the natural mother of the first defendant clearly established that there was no legal adoption valid in the eye of law. Consent of mother, which I read, affidavit filed, and also her father judging eliminating me from their family and to get the properties in her name and her other children's name. That is sufficient enough, and there cannot be any such hard and fast rule how it is to be, what exactly it is. Then the burden of proving the factum of self-acquisition of properties by the first defendant from his own funds was squarely on him, where he did not discharge. My submission is existence of nucleus, income from it, and joint family, that is proved by them. If they discharge the burden, then onus shifts. That property in my name is my self-acquisition. Till that time, it is not so. Here it says the burden is on me. It is not burden. The onus, if shifts, then I have to discharge. There is a lot of difference between burden and onus, which I did not explain to you. Out of 14, who pleads, he shall discharge the burden. Who opposes, onus shifts, then he has to probably evidence is to be placed. It is not as a burden, it is only onus. Then, 6. Under Hindu customary law, eldest son is not to be given an adoption. My submission is this is too much. For simple reason, nowhere there is any such prohibition. Even in 1989, Madras 334, which my friend cited, this eldest son shall not be given an adoption. Provision there. In Para 713 of the same judgment, it reads, apart from the materials referred to above, the circumstances that the plaintiff is the eldest son of his natural father should also be taken into account as disapproving his case of adoption. Normally, what's used? Normally.
Where are you reading paragraph number?
Paragraph 3.
1989 na?
89.
Madras para 30 ilvalla.
1.3 3 ಆದ್ಮೇಲೆ 3 ಪ್ಯಾರಾ 3 ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ
1 2 3.
After para 3, it starts with paragraph number 13.
Last column. 1989 Madras.
The present case, adoption is alleged to have taken place. Is that what you are reading?
Apart from the Shiva.
3 ಪ್ಯಾರಾ 3 ಆದ್ಮೇಲೆ
Apart from the materials referred above.
Apart from the materials referred to above, the circumstance that the plaintiff is the eldest son of his natural father should also be taken into account as disapproving his case of adoption. Normally, the eldest son would not be given an adoption. No doubt, there is no prohibition in law from giving the eldest son an adoption, but it is widely improbable in communities. It reminds me Mahabharata. When Bhima was asked to take the cartload of food and other things with two buffaloes, he himself states, Yudhishthira, for my father, Apollosadeva for my mother, Madhyama,
Yargo Badan.
That is the proposition because the eldest son, if he grows up, then the father will be at old age. Therefore, he has to take care. That's the proper one thing. Youngest children, when they grow, his mother, because father will not be there, they are supposed to take care of the mother. That may be the reason for it. But there is no prohibition. The judgment itself is very clear that there is no prohibition. Probabilities have to be considered. Therefore, to religious ceremonies, even taking that this customary law statute, I read again in para number the same BC there. No religious customs, not even Datta Homam, are necessary in the case of Shudras. Shudras, So all that is stated with respect to home, giving, taking, all whatever it is not so that is no religious ceremonies, not even that the home are necessary in the case of Shudra. Not are any religious ceremonies necessary amongst Jains or the Next is both the judgments of the courts below are concurrently wrong and the same can be substituted in such 100 cities. That's for our lordships to consider what evidence is available on the corner. We cannot make out a new case contrary to the hearing. I suppose making out a new case means pleading. Excluding the plea, outside the plea, if something is said, at some stage, the appellate court says, especially D16, what it says is to be considered as declaration adoption or adoption, usually worded as adoption plea. But plea in paragraph 6 of the plaint is very clear that for the purpose of preserving property is given existence. If that's not true, the recitals in the document reflects it. Repeatedly, I am submitting to the extent. It is nothing but events which took place in the family recorded.
Yes.
And there it said that yes, you are taken as the son. My husband was treated as son. You are taken him as father. That is, even now, I hope that you will take care of me. It should not be related in between. That's the desire. There it is said it is a pity. A construction of document. Nomenclature is not the what is called accepted rule. Nomenclature of document may be something, but what it reads is most important. The internal substance recitals ought to be considered. For that purpose, by sufficiency, no one has made out any question apart from the pleading. By sufficiency, there is a case where after the non-suit, likely the suit ought to have been dismissed. Instead, I have accepted these all the properties of property, these are the properties of property, these are my self-proclaimed properties based on the evidence. Both the courts can have right. As a question is properties of no substance, I base the question.
As regards the union, I learned from the establishment subject because he has appeared in the royal court. He knows better about the union. We will not argue on the question of law, the ladies and the reality of adoption, so-called adoption. Your lordship was pleased to ask last week as to how this Murli, who was not born in 1946, who filed this suit in 1991, came to know about the reality of the adoption rule, that is only a nominal, not to be acted upon, only to preserve the properties. And this suit was filed in 91. Unfortunately, this Murli died in 96, even before the trials commenced. Therefore, he was not questioned. Then, historically, the violent and Krishna's claim got transferred to a certain claim. Therefore, I am unable to say how he knew, but we did not I can be.
Obviously, he couldn't know. Obviously, he couldn't know.
I would submit these two things. Because of the conduct of the first respondent, who performed the duties of Karta, powers, exercising powers of Karta in the family, till 86. But though my father, the natural father of defendant number 1, our father, expired in 1996, but he expired in 86. Before that income, himself, he was the Karta. He was not the Papa suffered from so many disabilities. Therefore, he could not perform the functions of Karta. It's Rama Reddy who performed it. Never at any point of time in the death of the father did he not say that and these properties are my liability of the adoption. Never he said. It's only in 87 when the demand was made.
for the respective properties together. This has been stated by the first degree that there is an adoption date. By virtue of that adoption date, he is the sole owner of all properties. And even the properties purchased in the name of Karta Raman out of the joint family properties belong to him. Then only we got first time, not before that. Therefore, this is one probability. Conduct of the first thing. Second, we got Papa mother, natural mother of first dependent and the other side, was alive but still 2014. During the pendency of this regular settlement expired. She knew about what had happened. Probably she might have informed about the other parties about this. These are the possible sources. Positively, I cannot say.
So the difficulty is if all the predecessors of Muralish, if they don't have any difficulty with the adoption, exhibit D16, ಅವ್ರಿಗೇನು ತೊಂದರೆ ಇಲ್ಲ ಅಂದ್ರೆ when they have accepted the adoption, when they have allowed the adoption or this document to remain from 1944, 46, from 1946, what is the right of this Muralish?
In the 87, he did not discuss about the adoption date. Because my client was not born. He did not know. Only when demand was made for partition, all this has been discussed. And when he might, by virtue of the conduct of the information given by the mother, probably Muralish has not say there is only a nominal for purpose of preserving the properties. It's not acted upon. It has not been acted upon, it's not true. Because he was living with the entire family. So, this suit was filed. Only after suit was filed, you have to ask the evidence of PW2. Before the evidence began, his evidence was taken. He said, only about 4 years ago, I was between the portion decided by Rama Reddy and the others. That's it. That's why he was living together. Not along with his discharging from this duties of Kapta. Therefore, on the basis of the information given, we have not stated. But the question remains as to what is the validity of this adoption? Is it valid in the eye of law? It might have been styled as an adoption. The question is still there. But before we are going to have submitted about the HPP60, but there is one more. Say I want to submit. Before that, what was the law without the right, your lordship knows about the word Hindula on adoptions. Contained in Tapta Chandrika, Tapta Chandrika. I have done copies to the High Court inquiry. I pass on
Very good.
argument ಹೇಳುವಾಗ ಇದನ್ನ ಹೇಳಿದ್ರ ಏನು ಆಕ್ಚುಯಲ್ ಲಾ ಏನು ಅಂತ ತೋರಿಸಿದೆ.
Light comes from all sides.
ಅದ್ರಲ್ಲಿ ಏನು
Propositions of law at any time, whenever
what has been said here, we will see. In support of those propositions, we have argued. We will see what that is not for ancient legal law. For your lordship to get that. Kindly go to page 4. This will not have taken from the High Court. Original book is in the High Court. Kindly go to para 4. The third portion, the third part. The role of the third option is evolved from two important texts. The text of those of Vasishtha, metaphor and Saunaka, which reference is already given. So this is the source. Manu, Vasishtha and Saunaka. Saunaka is not a different one. It is metaphor. So I request your lordship to go to text 7, article 1. It contains its narrative in articles. This is not a translation in Sanskrit. Article 1. No adoption therein The adoption is valid unless the person giving adoption is competent with the adoption. The person adopting is competent with the adoption. The person to be adopted is capable of being given and taken in adoption. And therefore, the formalities essential to the validity of the adoption are carried out. This is an essential function. And the formalities have to be carried out. This is not in the last year good article 2. At page number 10. Like before that, kindly do not see para 9. Page 9. Page 9, first para. An adoption brought about and misrepresentation is brought and mistake is valid. Valid adoption is the consent. The person's but it seems also of the person adopted is a PH. This is comment. I will not argue to next page. Depends on not given in our only names for
ಯಾರು ಪಿಂಡ ದಾನ ಮಾಡೋದಕ್ಕೋಸ್ಕರ propitiate
adoption was for a pious purpose. It is not discharging pious duty. Performing obsequies. That was the purpose. Now it has come down to not just take property. All that has been forgotten. Obsequies, performing duties of the son. Because it was believed that if a person is Hindu dies without their being his son, we will go to them. It is called Punnamanarka, a separate because God of Naraka. Punnamanarka was there according to the belief. Therefore, a person, not father or mother, who did not have a child, who did not have a son, not child, used to adopt for the purpose of performing the obsequies, discharging pious duties. That was the purpose. Now, gradually, that has been forgotten. People are fighting for property. Article 2. The parents alone may give the natural son. The license is the the first dependence is father has given. Son, mother, there is no reference. In the evidence, even that is not there. It was given in adoption to Guru Brady, that's all he has said. Who has given? He has this. I will not have so the parents alone they give the natural situation, provided they have attained the age of discretion or sound mind. This is the requirement. Then the Lord should go to get 17. Commentary is similar to the development. There are necessary to be given. Lakshmi also Article 9, page 69. This throws some light. Any male in room, they are out number 2. Who have been adopted? Number 4. The male in room may be taken in adoption, so female was excluded. Adopted in adoption provided is of the same caste. Earlier, same caste was an necessity. It was the requirement. Of an age and status to be taken in adoption, and not so related to the adopting father, who has to get married with the adopting father as a middle state. Legal or not, but why is there? This does not affect us. From the subject of what my life is, I believe that this community. So this class 3 is not as far as marriage is concerned. Kindly go to Article 12. No adoption is valid unless thoughtfully delivery lacks in some. Therefore, delivery by the natural way. acceptance by a must. And two, the ceremony is also two. And such other ceremonies are essential to the value of according to non-usage of there is according to the non-usage. Usage will not vary from place to place. But ceremonies are there in their community. Cannot be done clandestinely without knowledge of anybody. There must be some ceremony, there must be present. Otherwise, they would not know that he has been allowed. So this is essential. That may be Article 11 also. Page number 83. Upon valid adoption by a Hindu himself, his wife or his widow, adopted is transferred from the natural family to the adopted family as effectively as it was brought in. Yes. Once adoption is made, valid adoption is made, the boy goes to the other side. He can disconnects himself, disassociates himself from the natural fathers. He becomes member of the adopted family. Therefore, thereafter, by submission, he cannot do the name of the natural father at all. And your Lordship has seen in all documents, even at the age of 56, 57 years, he has described himself as son of Papa Reddy. Yes. And many of them are even the record of rights, but which he claims, in respect of the lands which he claims, stand in the name of Papa Reddy. They were standing in the name of Papa Reddy. And adoption once made cannot be cancelled by the parties thereto. Or can the adopted son renounce the status as a return to his family? The adopted son may give up or modify his rights to property and inheritance. The adopted family either before or after adoption. So he may give up his rights to adopted family. The son does not want. He can give up. But this son does not want. Then your last name would be 89. Article 13. One, on a valid adoption, the position of the adopted person in the adopted family has rights, liabilities, and disabilities is in all respects same as that of natural son of his adopted father, except that he is not entitled on succession to share his adoptive father's property equally with an afterborn son. This is not another son of his adoptive father. He is disqualified from succession where the adopted father is himself disqualified. These are the relevant provisions. Other provisions are there. They may not be necessary for deciding this case.
Papi Reddy Thiro Jawala. When did
86?
Papi Reddy died in 86. Papa Reddy.
Totally doubtful. Not even hear anything. Let us totally dumb. And like totally illiterate. Did not even write one letter. Because the eldest father himself said, this is not the how Lord I would push to last.
Action?
In the evidence is not in the evidence, life powers and does not say anything that the father and mother have given no.
No, how could he say? Because he was just a 5-year-old. No, he was a 5-year-old boy.
No, at that time 5 years. The evidence was given, he was about 80 years.
It doesn't matter. When, how do you say that? How does he remember? It will be expecting a lot of.
Person who believes that his natural father could have said it in the evidence.
How can he say? The next question next question would be, how do you remember that as a 5-year-old boy?
I don't remember, I learned it from others.
Therefore, we can't
this evidence was given in the case. Was not an aged person, educated person, probably retired also.
Could be. But you are asking something about what happened.
First thing you should have said this, my father and mother
Now, how does he know? How does he know?
Then he cannot speak about
No,
adoption.
how does he know?
So he will have to totally rely upon expert D60.
Absolutely.
Therefore, there is nothing else, there is no other evidence. You have to adhere to that. Now, you defend, very easy, but according to the
Therefore, the onus should have been on you.
very good expert D60.
Yes.
That number.
167.
This was executed in Myanmar.
Yes.
That is also not dependent on the also now Myanmar side. Yes, you madam. First time, 167. So some sort ನಮ್ಮ ಸ್ಕೂಲ್ ದತ್ತು ಮಾಡಕ್ಕೆ is all statement.
Yes.
No way this lady has said. This is father and mother, therefore, he has written, yes, sir. No way. So, this statement is totally relied upon. It's totally outside of the task. This is an essential. Giving a child, Supreme Court has to be essential. Giving a child is a must. That is objective. Therefore, this has no value.
No, the problem is, what you say is right, but who has to question that? Question ಮಾಡಬೇಕಾಗಿಲ್ಲ ಅಡಾಪ್ಷನ್ ಅಲ್ಲ ಅಡಾಪ್ಷನ್ ಕೊಟ್ಟವರನ್ನ ಕ್ವಶನ್ ಮಾಡಬೇಕು ಅಡಾಪ್ಷನ್ ತಗೊಂಡವರನ್ನ ಕ್ವಶನ್ ಮಾಡಬೇಕು.
But for the adoption, there was no adoption as lately you would have got the property.
Yes, absolutely.
No, that's the only thing.
Correct.
That's the only relevant okay, the concept, we can't have local study. We have local study, let's find out, we have local study. Because this, and the death of but parliament which no adoption, the properties are given upon us and all the members of authorities. As to our 1935, as to what should happen in the United States. I don't dispute that on the death of Europe, otherwise, there is no meaning of it. We did not get. This is not criteria. Currently, this is coming to
yes.
Section 5(2) nothing really sometimes it is used after 3 rules or which are not inconsistent with the project. So only in respect of the project state leader is that citing variance with customary in this act will prevail, otherwise all other projects will continue for that. This is what of this.
Yes.
Then we have this full estate is defined under section 3 last week. Full estate means some total of rights exercisable for any property, including the power of unfettered disposal, either by roads and by rail. Yes. So if it is an absolute property, full estate. Person. Yes. Otherwise, it is a limited estate. Yes. Limited estate is also different. Limited estate is free estate other than that. But why do you want to Really, it was the first part. You just realize because there is no violation of conservation. But what is the kind of estate? This is the limited estate. Absolute full estate. External solution because limited estate. Full estate. Nobody can contend that because of full estate. Which you are another estate. I'm not disputing. I'm not saying that it's but you have to submit to read the other projects also. After that, you have to look at the not to look at just reading sense.
Right.
Why? I wrote this to us. What is the type of estate? Yes. Yes. What has been reported is that like circumference at all, circumference affects this partition. But this possible is not now applicable. He is not applicable. He is not. He is not. So he was concerned. When joint family property passes to single co-partner, and in this case there is no co-partner. When it is not a co-partner. Yes. It is survivorship, which is so far subject to the rights and freedoms of classes, enumerated clauses. Now, why not write this by of this time? That's because the only here at that time. Yes. Then, such church to be not only here. There was no other process. Subsection to classing is not also not. Then you are not go to section 9 also. It deals with adoption. Document of access to senior cost of adoption. Other than such, we have taken the unit. So there is a restriction also. It does not, advance. This is a provision. We have property, except that just come from the husband, we cannot dispose of.
Everybody is arguing, everybody is quoting the law, but I am asking you one simple question. How did the family, how was the family managed from 1946 and onwards? How was it managed? Adar ಬಗ್ಗೆ evidence ಏನು? Reunion. Adar ಬಗ್ಗೆ evidence ಏನು?
I'm not going back.
Because I have gone through the evidence. I've gone through the evidence, but there is no evidence regarding reunion. There's no evidence regarding reunion.
One statement.
ಏನಪ್ಪ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಏನಂದ್ರೆ ಮುನಿಯಮ್ಮನು ಅದೇ ಊರು, ಇವರು ಅದೇ ಊರು, everybody ಎಲ್ಲ ಒಂದೇ ಮನೇಲಿರ್ತಾರೆ ಎಲ್ಲ. And this man claims himself to be the father.
The other family, they have union. It's not everybody's case of the breed has gone there. Property itself has not, there is a breeding. Right? Right, it has been said.
ಎಲ್ಲ ಹೇಳಿದ್ರೆ ಬಟ್ ಎವಿಡೆನ್ಸ್ ತೋರಿಸಿಲ್ಲ. ಪಿಕ್ಚರ್ yes. Yes.
Yes. Property taken the inheritance from another children. The property, this is not dealing with street or partition.
Yes, yes.
Property taken the inheritance from other children. Or property taken the inheritance from a husband. So this applies. So it becomes a street or a property.
Yes.
Property is the husband. Because she is the body is not and the body is independent. Yes. 60. Must limited estate.
Yes.
Nature of estate in property inheritance from males. In property of the Shriva as divided the female should take the limited estate.
Yes.
But in respect of those properties, all other properties are limited.
Yes.
What is called succession? Your life was what happens to property? The succession to female property is not very interested. As follows. The first instance, try to improve that. The second instance, in the absence of children and grandchildren, the husband, if any, lawfully married to the husband. The husband says, the husband says in order of succession.
Yes.
So under this class, there was no adoption.
Yes.
This is not section.
That is before 56. That is before 56. That is before 56. If she died before 56, what you said is right.
56 on except this so-called adoption, we can't dispose of the property. Getting out of both sides, not guilty. So entire thing revolves on ultimately what is that. This is custody is also accepted. Respect to them to speak of property. Any person, whoever female, inherited speak of property, and the full estate. Suppose we get it. We get to not Muniamas, we get it.
Yes.
So these are the only two things. Otherwise, it's a limited estate. And the dependent number one, and the value has to be a full estate. Not. I should not from the husband. The party is not in successful of the she could not have disposed of any manner. He will not be advent of yes. After 26 years, by virtue of such communication, she would have done anything.
Continue tomorrow.
I require all the candidates.
How is it? Very evidence for the point out, Mari. Don't read the whole thing. Reunion ಬಗ್ಗೆ ಏನಿದೆ ಅಂತ. Whatever, but you please mark it out. Don't take. But other don't consume more time. Now that everybody is dealt with all the other issues, please point out the only evidence which indicates of reunion, even the pleadings also. Correct a point out, mark point out. Yes. Further hearing yes, Mr. Ramesh. Yes, ನಾಳೆಗಾ ಆಯ್ತು ಯಾವತ್ತು ಹೇಳಿ ಮಂಗಳವಾರ.
Court officer? Court officer, serial number 52 ಏನಾಯ್ತು? 52. Final hearing 52.
ರೀಚ್ ಆಗಿಲ್ಲ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
Next week ಬರುತ್ತಾ? Thank you.